Okay, well, as it is 8:30, we will go ahead and get started today. Um, we sure the rest of the people will trickle in as we're getting started here on part two. As a just a caveat here, I just traveled and I'm in Central Time right now, so if I say a break and I seem an hour, I'm going to try to remember to say everything in Mountain Time. But if my clock's an hour ahead, if I give you a time that seems well off, please correct me, and we will get on the same page for that. Um, Let me go ahead and share screen with where we are. We'll start with the same house cleaning issues that we started with at the beginning last time. So as you know from last time, I am Anthony Perillo, an associate professor and the forensic psychology training director at the University of New Mexico in our School of Medicine, where I also do these competency examinations for the state as well as train and supervise our forensic psychology postdoctoral fellows at the University of New Mexico in conducting competency examinations as well as any other kind of um, forensic psychology practice or policy issue that comes up. A couple of issues today, of course, the same logistic issues. To keep this as engaging, we encourage you to have your cameras on, also have your microphones muted unless you're going to be chatting, and then you can unmute at that point. At as we start this, go ahead and sign in using the chat function. If your name in your Zoom screen is inaccurate, you can go ahead and update it to change your name. And there's some instructions there on how you can go about doing that. Um, Again, there will be today, since today is part two, in terms of continuing education credits, there will be a link to a survey that you'll complete that'll be posted near the end of the discussion today. You'll want to save that link or open it before the webinar closes. And I said webinar because I am in autopilot mode for saying this every week in the Law and Mental Health series. Bear with me there. Um, you'll have roughly 48 hours to complete a CEU survey on the matters here. And after you complete that survey is when you'll have a certificate pop up for the credits for the 2 day webinar for the 2 day training, and make sure that you save your own version of that certificate that pops up. We at UNM or BHSD, we won't have certificates themselves. You have to complete the survey directly and then save the version that pops up for you at that point. Again, neither I nor Randy have financial arrangements in the content of this activity. We may talk about an instrument here and there that Randy has developed, and we can reference a book, and there's information in those books, but um, we're not endorsing explicitly using that stuff. It's just more informational in terms of there's more information in this book, and an example of an instrument that some people use in competency examinations, but we do not get a direct financial benefit. This work is part of our salary-based work through UNM, and we speak from our professional capacities as ourselves in this field. So the stuff that I say and the stuff that Randy says, they are the views of ours alone, and they do not represent necessarily the views, policies, positions of our employer, the University of New Mexico. They do not necessarily represent the views of the state. The things I say don't necessarily reflect the views of Randy, and the things that Randy says don't necessarily reflect the views of me. We are speaking from our perspectives in this field. Um, Again, the names of those who complete this training will be forwarded to the Health Sciences Center. Make sure again you secure the training certificate so that you have that later on for any CE audits or anything like that. You do have to attend both days to receive the CEU credits and certificate. Um, and again, you'll be signing in as you trickle in here. I see many people have. And then when you leave, go ahead and sign out as well. All right, and there's the same instructions there of changing your name if it's not matching yours. Oh, all right. And again, you know, keeping microphone muted. I am, you know, Randy and Elena will be keeping their eye on the chat box if people have questions or comments throughout here. I am also more than okay with people unmuting and asking questions and commenting as we discuss stuff. It doesn't have to be me necessarily explicitly prompting you to talk or share your stuff. If a question comes up, you can enter it in the chat box, but you can also unmute and ask or share if you feel comfortable with that. The default would be using the chat feature, and then there can be, of course, can be a dialogue as you see fit with that. We will open up different spaces at different times for questions, comments. And there will be different appendices be ready to access during training. Today I will have a couple of Slido.com prompts. I think there's only two or three. There'll be a QR code that you can scan, or there's going to slido.com. That's SLIDO.com, and then it'll tell you a code. But I will give you time as a heads up of responding to those prompts. Where we left off last time was more in the conceptual issues related to competency examinations and then starting to get ready for the competency interview. That's where we will pick up here. For the first half of the day, we will be focusing on issues related to actually conducting the competency examination itself, the interview, and considering any other sources and information as you integrate it into your examination, as well as any kind of hiccups that come along the way, key issues to consider, and some more unique aspects of doing these in New Mexico. The next portion, for those of you that attended the May webinars, is a rehash of the content that we discussed there in terms of AOT civil commitment considerations, given that we are required of doing that now in certain competency examinations of assessing eligibility for mandated treatment. We will go over that stuff again for those of people that were not here for the June one, but it'll be a more abbreviated version, as well as testing considerations. Some of the content that we discussed from that May webinar, as well as considerations on response style. And through this, we'll have a series of vignettes, hypothetical considerations, and then we will transfer the end of the day into report writing and testimony. Considerations for competency examinations, including some simulated shared examples here of direct and cross-examination for a competency examination. All right. To rehash the final slide of where we were a week ago, to pick up from there, we ended with the preparation for conducting your competency examination interview And I wanted to just rehash again. These are the questions that I would consider in order to determine whether I am actually truly sufficiently prepared to interview the defendant to do a critical step in examining their competency. So the first question there is the one that I would say is 100% required. Do I have an order to do this examination? In the context of a court-ordered examination or role here. If I'm told I'm going to examine this defendant, but I don't have the order yet, I'm pausing until I actually have the order that indicates that this examination has indeed been ordered by a judge to occur. Now, this doesn't necessarily apply if you're being privately retained by a defense attorney or by a district attorney or otherwise prosecutor. But if you are in this court-appointed kind of role, you need an order before you actually conduct your examination. I want to know what the current cases are and what the charges are. This is essential information for me in the moment if we're going to assess someone's understanding of the proceedings. It is kind of a hiccup if I don't know what the actual cases or charges are, and I'm assessing somebody's understanding of the cases and charges that they're facing. So I want to be able to know what are they facing potentially? What are the legal charges that they're facing? Are they facing multiple cases? I also want to be able to look up on my own if there are other cases ongoing right now that I don't have an order for. That will help me tailor the interview to just the cases that I specifically have an order for, but will also clarify for me if there's any confusion from the defendant. And I've had this before where I ask somebody, "Do you know what you're charged with?" And they say something that doesn't line up with the case that I'm ordered to examine their competency for. But if we look up their record prior, and you can do state record through nmcourts.com, a database where you can look at any other ongoing case proceedings, that can help clarify if they talk about I'm charged with drug possession, and the case you're examining competency for is disorderly conduct. Like, well, actually, you're charged with disorderly conduct. But knowing if they were recently arrested for some sort of substance possession, but you don't have an order to examine that competency, that can help clarify. I'm talking about a different case. Do you know what you're charged with in? You can always provide a cue there. It happened a little bit before that one, or the one that involved, and you can mention an address or some sort of detail that prompts, do you know what you're charged with otherwise? Um, and that can help clarify if they bring up something that's just out of left field for you. I also want to know what are the allegations? nmcourts.gov. Thank you, Marla. I might have said .com there, but yes, thank you for clarifying there. What are the allegations? So this is where the criminal complaint comes in. Regardless of what the charges are, I also want to know why somebody has been charged with that. I want any kind of documentation, particularly from an original criminal complaint, at the very least, that or some sort of indictment that gives me some details of not just what the charge is, but what are the incidents, what is the time frame, what is going into the actions that led to somebody being arrested and or charged with the particular offense that I am examining. Because we want them to know not just formally what they're accused of, but also do they understand what it is, what incident or incidents occurred that led to these charges. There is two people can be charged with robbery and the actual allegations be entirely different from each other. So it is insufficient for me to assess someone's understanding purely based on their charges. I want to know what the incident, what entailed that led to those charges. I want to know where we are in the case. So I want to know if we are at the initial proceedings, if a plea has been entered or not. I want to know if a plea has been entered and we are in the middle of a trial. I want to know if the trial or plea version has been resolved and we're in the sentencing phase, because competency to proceed is focused presently on the ongoing processes relevant to what the person is facing. And there are different decisions, different considerations that can go into sentencing versus purely responding to the allegations, to live dynamic responding to allegations as a trial has progressed. I want to know if there are any specific attorney concerns. There should be, um, based on state law about the reasons for motioning for a competency referral. But if there are particular concerns, it's important for me to understand that so that if those topics don't naturally come up during my interview, I can address them later on. And I think I have an example here later of what I call basically like, you pull on the loose thread and everything unravels. There is a case there where I was about ready to wrap up. I thought this person seemed completely psychiatrically stable, said the right things. I had essentially no concerns about competency, but there was a specific attorney referral question that had not come up yet. And so I'm ending the interview, making sure I go back to that. And do you even know why your attorney was concerned about competency? And then I brought up some of the stuff the attorney had said that they said. And as we'll get into later, that unraveled the entire sweater. So it's important to understand not just what you're assessing in terms of the statute for competency, but if there is a particular basis from any attorney defendant interactions that particularly elicited concern that prompted the motion, so that you assure when you do your competency examination, you're not just addressing the standards broadly, but you're addressing those standards in the context and accounting for the particular concerns that came up. And then logistically, do we have an appropriate way of meeting? If the person is incarcerated, do I have a room there for them to be able to interview remotely with me? If this is going to be an in-person evaluation and the person is out of custody, do I have the office space for that? If it's remote and the person is out of custody, am I assured that they are going to be in a place where they are free from distraction, can be able to hear me and see me, and will have their privacy respected? So, as one hypothetical here, let's say during your examination, Evangeline, she describes her charges accurately. She says she has an alibi for the allegations, that she was at church with her mom at the time that they said that she did her offense of this burglary. She says she's going to present this evidence in court, and there's a lot of people at church. She's got a lot of people that can say that. And she's not going to accept a plea deal because she just, as a matter of principle, I will not plead guilty to something I didn't do. All of this sounds within a rational base to you. She seems to understand her charges and all of that. But you didn't have an attorney referral beforehand. You didn't have details about why competency was asked. It's only after your interview that you receive that referral. The attorney indicates that Evangeline accepted a plea deal, but that at the actual hearing to enter that plea, she rejected and said she wanted to go to trial, because her mom told her it's not God's will for her to go to jail. That she talked to her mom and actually has reconsidered, and mom said, "Do not take this," so she's not going to take it. The attorney also adds that Evangeline's mom died when Evangeline was 12 years old. And let's assume, being that this is adult court and it's a burglary charge, she is well older than 12 now. Um, how does this affect your initial examination of Evangeline, and what would you do from here? And whether through the chat or unmuting, I wanted to throw that out there. So if you had zero concerns from paragraph one, do you still have zero concerns now? Okay. Okay. So we're getting this message in the chat of we need to go back and have another interview, because we have this new context where we have a disconnect now between stuff that Evangeline said in our interview that on the surface seems completely rational, logical, within the realm of reality. But now with the referral context, we have information that suggests not just what she factually reported to you in terms of I would never accept a plea. There's a little bit of disconnect here. Now, technically, she didn't actually enter the plea, um, but she hadn't given you an impression during your exam that she had at some point been willing to accept a plea and had a change of heart. So there's a little bit of a disconnect there, but as I think is referenced in Marla's comment here, there is some potential delusional thinking that was not evident during the interview on the surface. But now that we have a factual disconnect between being at church with mom and mom having been dead for years, and the added context of her decisions have changed because she is either feeling or hearing her mom tell her not to accept this deal. That can change our understanding, particularly of her understanding of the proceedings and her ability to assist in her defense, and to rationally consult with counsel. So this is an example why it would be critical for me to have the attorney referral form in advance, because if I had had that at the time and Evangeline tells me she's going to present this evidence in court, now we can open up those clarifications in terms of I was at church with my mom. Tell me more about that. You know, where was your mom? Is your mom alive? Your attorney seems to, your attorney seems to believe that your mom's been dead since you were 12. How does she respond to that? Understanding more about what her current relationship is to her mom, or her understanding there. If I had the information, I can get it live in that moment, address the discrepancies, and then that would really affect my impressions on competency. But now I have to go back and schedule another interview. If anyone has had to schedule a second interview, um, any potential any potential concerns or hiccups that you can have when trying to schedule a second interview with somebody.
They were on their meds and then went off, or vice versa. I've definitely had where I've gone for a follow-up interview and the defendant was since placed on suicide watch, which then can't proceed and then bumped out further and further, which when there's multiple weeks between when you're meeting with them can definitely impact their presentation.
So interceding event. So when you do that follow-up interview, always wanting to check in on any kind of happenings between time one and time two that could potentially account for differences in their presentation. We're always, because competency is present state, we're going to give more weight to the most recent presentation as representing their current abilities, unless there is a unique circumstance that would suggest that some discrepancies are an acute temporary blip, and actually the last meeting is more representative of what they're capable of. Um, but we can get into that later. Um, as Surabhi mentions here too, in the meantime, let's say your initial examination was at the detention center where they were detained, and since then they've been released. That can really complicate things in terms of finding the person, and the logistics of arranging another interview. And I think that this has happened to multiple of us before. And of course, if somebody gets released, it's both the logistics of finding the person and getting things scheduled again. And there's a number of different potential intervening events there and circumstances. All of that can factor into your understanding of the person's competency as well as your mere ability to engage in the examination. So now let's say you have prepared for your examination, and you are there in the interview room, whether physically or remotely, with the defendant now. One of the at the onset, you're going to be giving a number of notifications to the examinee about who you are, why you're meeting with them. Um, I typically also at the very onset, I ask them for their name and date of birth, and I tell them, particularly when it's in the detention center, I ask for that, so I can make sure that they brought the right person who I'm supposed to talk to. Um, and I have had it before with some common surnames and common first names where the detention center actually sent me the wrong person. And if I had not asked, there were two people with the same name or similar names, different dates of birth. And if I hadn't known that, I might have done a thorough interview of somebody um, who had no psychiatric, no cognitive impairment, no concerns at all, or was a completely different person otherwise, and have evaluated the wrong person. So I always ask the person directly if they can tell me their name of date of birth before we even get started, to make sure that the center brought if they are who I'm supposed to be talking with. Once they confirm that, or I have some sort of evidence. Of course, sometimes you might meet somebody that is either disorganized or impaired in some way where they have difficulty saying that. If I have some sort of identification marker, whether it's a booking sheet or if I go on their detention center custody list and see the booking photo, to just see if this is actually the person that I was supposed to talk to. Anything that can give me indication to confirm that this is indeed the person that I'm ordered to examine. And once we do that, then I'm sharing a number of different things with them before determining whether or not they are providing assent to participate. And we got into last time the differences between consent and assent, but I'll get into that with the code again here in a little bit. But in general, when you think of those notifications, the beginning information of what you're going to share with a defendant before you actually start the examination and determine whether they're willing to proceed about that, what kind of what information do you provide in these notifications? And if you want to look at the chat, Randy has provided another anecdote about the completely different person that was brought. And a similar a similar thing happened to me fortunately at the very beginning, where of the examination. Thankfully, this is where the date of birth came in, and I was like, okay, this is not the right person. And then they brought the next person in, and they were very, very different presentation. But notifications, what kind of stuff goes into your initial notifications with the defendant? Yeah, what this is about. Why they oftentimes, especially if somebody is detained, it is not uncommon for someone to have not had contact with their attorney since the competency exam was ordered, and for them to just be woken up by one of the guards and brought to a room and not told what who they're meeting with, what they're meeting for or not. Maybe they're expecting to see one of their parents and then they see you. Um, So they may have no clue that they were going to meet with anybody, let alone who you are and why you've met with them. So I'm always being clear on what my name is, what my role is, and why I'm supposed to be meeting with them. You're also clarifying the what the purpose is and the limits of what your report is. Uh, that this is not a therapeutic relationship. I'm not providing therapy. I'm ordered to understand what they call competency. Basically, the court's asking me to assess how well you understand stuff about your case and how well you can use that stuff to work with your lawyer and go to court about your case. You know, who gets the report? Thinking about the limits of confidentiality. These are all essential parts to those early notifications. And I'll bring up the code now that can clarify some of this with us. So if we look at New Mexico Administrative Code, um, we are generally provided even when people are legally incapable of giving informed consent. So I'm going to broaden that to more say the message here is regardless of whether somebody actually understands and demonstrates the ability to consent, we should we should inform a person why we're meeting with them, seek their agreement to go along with the examination, and consider their preferences and the overall best interests, even if they are incapable of consenting. And that assent and considering preference and best interests, these interplay with each other. Just because you are ordered to do the examination, and if they are disagreeable and you're saying, well, I've got to do this anyway, I'm just going to ask you questions anyway. New Mexico code says we shall still consider their preferences and the broader best interests in terms of whether we should proceed with the examination, or the particular interests of the best interests of that individual. So this is where you can have situations where somebody is agreeable to proceed with the examination, but you're concerned about their emotional state at that time in a way that has nothing to do with competency or less related to competency, but in a way that could compromise their immediate well-being or compromise the examination. You could determine, even if they're agreeable, it is not in that person's best interest for us to proceed, so we're going to pause and reschedule. We're going to pause and reschedule for another time. But you don't need consent when your evaluation is ordered, but you should seek assent. You want the person to agree. So after giving notifications, you want to ask something to the effect of, are you okay with me? With all of that in mind, any questions that you have, I'm going to go ahead and start asking questions if you're all right with that. And getting them on the same board, getting them on the same page in terms of The evaluation is starting now if you are agreeable to that. Now, our orders talk about competency being evaluated. So we get ordered to do the evaluation. Um, and this is where there's discussion, some of it even ongoing now along the state, in terms of whether the defendant is ordered to participate in the examination. Now, New Mexico code discuss or the orders that we receive frame it from the examiner's point of view, partly because the order is being sent to the examiner. It is saying the psychologist shall do this examination. So we get ordered to do the examination. The order does not explicitly say the person must complete the competency examination. But we do know that there are judges and attorneys out there who would consider explicit defiance of the broader order of competency examination to be a potential contempt charge for a defendant. I believe, in fact, recently, I think, Randy, you had a conversation both with a judge and an attorney. I believe that's something to that effect of if there was an order for competency examination and the defendant actively was showing a pattern, I refuse to do one, I refuse to do one, I refuse to do one. Would you consider that contempt of court? And both unequivocally said absolutely. If
Yeah,
they
it was two judges,
two
Anthony,
judges.
and they were when I told them that many examiners instructed defendants that they had a right not to answer questions and not to participate, they expressed surprise. They referenced contempt of court, but along with that, they acknowledged that they would be very reluctant to adjudicate a defendant as being in contempt of court for a refusal, given the potential complications of figuring out, well, is this a refusal that's anchored in mental illness? And do you really want to adjudicate someone as being in contempt of court if this is not, if this is something well beyond obstinance or oppositional kind of conduct? I'm just wondering, because of my lack of experience in New Mexico, if there's more than one order that could be used by judges. I don't, there may be a model order, and in that model order, it may be the examiner who's ordered to carry out the exam rather than the defendant participating in and undergoing examination. But what if there's a judge out there writing, what if judges are writing different orders, as was my experience in other jurisdictions? A judge could, maybe judges are ordering defendants to participate. I don't know, but I haven't had the experience in New Mexico.
Yeah, and I will say anecdotally, I haven't seen any orders that were framed in a way that ordered the defendant to participate in it, or that all of the orders that I've seen in different districts that I've worked at here have been framed toward the psychologist, and I'm assuming largely because the order goes to the examiner, and the order isn't necessarily sent to the defendant. But I have seen the language slightly differ across different districts or even different judges, which at least highlights to me that I think those orders are more of at least my understanding is it's more of a template, a guidance rather than a code of this is how it has to be, how it has to be written. I've seen amended versions or different language used in different districts across the different orders of how they go about with the formal order. The New Mexico Code also talks about in forensic settings and court-ordered settings what kind of information should go into broadly informed consent. Now, again, we don't have to acquire informed consent, but we are seeking at the very least assent so that, and looking at if people are capable of providing consent, we want to provide them all the information that allows them to then do that. So this can be a guidance for us that psychologists you shall explain the limits of confidentiality at the onset before the evaluation begins. And that explanation should be documented. So this is where we get back into the report that when we talk about forensic examinations here, it is critical as part of your component of the notifications that one component at the very least be about the limits of confidentiality, and then you noting in the report how what you actually explained to that person. They should also clarify when we talk about those limits how the information from the examination will be used, who will have access to the examination, what the procedures will be in the examination, and what the purpose is, so that the person has the opportunity, if they are capable of providing informed consent, to then consent to proceed. But regardless if they're capable of it, giving them the information to provide assent so you can determine where they are as you attempt to proceed with the examination. So you want to clarify how your examination is going to be used, who will get it, and the limits of confidentiality. I want to throw out another hypothetical here. So you introduce yourself to Tyler, who you've been ordered to do an examination for. You're starting to explain the purpose. You get to this is for competency about your case to see how well you understand things and can go to court. And as soon as you mention court, Tyler says, I know I'm in big trouble for biting that officer. He says he's very sorry for doing it. He just wants to take a plea and let the court know he'll do drug treatment. In your notifications, you had not gotten to the confidentiality limits yet. You had started to explain why you are meeting with the person, and then they interject all these things. What do you do from there? Do you assume that the evaluation has started and just start writing? Okay. We have at least one no. Don't take notes about what he said, but stop him. And this is where I would also, this is a consideration of wherever you are in the notifications. We know now we have a person who is sharing some information that could, if certain parties in the court were aware of this information, could potentially harm them in terms of an admission of guilt, um, transparency in terms of what kinds of decisions they would accept in a plea deal. Um, that is all information that if it were explicitly knowledge to the state, that could cause some unintentional harm to the defendant prior to their awareness. And so this is where I would immediately also get into clarifying the limits of confidentiality. Um, I usually at that part go, I haven't taken any notes yet. I haven't started recording anything, but before we discuss anything further, I want you to know that what we talk about here doesn't necessarily stay secret between us because after I do this examination, I will be writing a report. And that report will go to the judge, and your lawyer will see it, but the other lawyer will see it too. It will include some of the stuff that we talk about. and then seeing how they react to that, and then getting on with the rest of the notifications. Another hypothetical here. All right, let's say you tell Lucy about the purpose of the exam, the limits to confidentiality, etc. She nods along, says, "Okay, sounds good." With probing, you get the impression that she didn't understand anything that you said. Um, in fact, she thinks you're a new therapist there to help her. She reiterates at the end, though, let's get started. I'll talk to you and do real good. Um, what are what are your thoughts in terms of proceeding with the examination? Any concerns about proceeding? Anything that you would do before proceeding? Right. So we can do a gentle reminder of the purpose of the examination, the limits that we're not that I'm not your therapist here. I'm just here to understand your competency. Um, the person says they're gonna do real good. I'm not hearing anything in their conversation there that suggests that their misunderstanding is necessarily factoring into whether they're agreeable to talking to you or not. Some considerations you go is if their misunderstanding is the sole basis of whether they're willing to talk to you in the first place. I want to reiterate and clarify that. But this is also something, again, we're looking for assent over informed consent. Ideally, we would have consent, but some people we do not know if somebody's capable of it until we actually do our examination, if we actually determine that at all. Um, but you're thinking about if the person is agreeable and it is in their best interests and in their preferences, you can proceed. Now, if Lucy brings up, I like you, you're a good therapist and all that later on in the examination, I might clarify again and redirect. But at a certain point, again, because we search for assent, at some point, if it repeatedly comes up, I can continue to just move on. But I would want to re-educate the person, partly relevant to competency to see how well they're taking in new information or clarifying information. But if there becomes a stagnated part where there's diminishing returns in terms of going back and educating and clarifying about the purpose of the examination, I will proceed at that point. Going back to Surabhi's question about refusing, does this mean that we shouldn't be telling defendants that they can refuse to talk to us? I believe at the very least it tells us that we should be very mindful and consider what we discuss with that defendant or how we bring that up. Um, there is still, there's discussion about whether or not the person can refuse and not get in trouble. We don't want to provide false information that says if you don't talk to me, you're going to get in trouble. You have to do this. Um, but keeping it as open, we don't want to mislead people into how purely optional this is, I would say, because even if it is argued that it is technically optional, it could be optional with judges interpreting this having negative consequences if the person opts out. So I would consider if you're going to bring up the order and the limits of the order, I would consider restricting it to not give a false sense that there will be zero consequences, but also not overstepping and basically coercing them into it by saying, you do not want to give the impression that they will be punished if they don't participate and they have to, or they will face consequences. But at the very least, typically, when somebody doesn't participate in the first time, usually we try at least one other time. You can reiterate with the person that the examination has been ordered. So if you don't talk to me today, I will probably be trying to talk to you again and meet with you again, and this will kind of stretch this out a little bit longer. But you don't want to give false impressions either way. So let's say you have assent, you're doing the examination, um, you're going to start your interview. You want to gather relevant background information. Now, I want to clarify here in terms of information that is relevant, especially with the emphasis here in the last year in New Mexico about relevancy focused reports, the information just put in the report, the information that's relevant to competency. There is difference between questions and information that is relevant to your exam versus information that is relevant to your findings and your report. Questions and information that is relevant to the exam is much broader than information that is relevant to the report. When you are examining and interviewing somebody, you are focusing on information that could be relevant to competency, but you will not truly know until you get that information. So you can ask about clinical diagnoses and upbringing, and ultimately they discuss their childhood and upbringing, and none of that information ends up being relevant to their competency. But for another person, their discussion of their developmental background and their upbringing could prove relevant to the impairments that you see or the impairments that you don't see that are relevant to competency. You won't know it until you ask. So this is where we get into just because you asked it and you got the information, it doesn't necessarily, that could mean it was relevant to assessing the person's competency, but it doesn't mean that that information is ultimately relevant to your examination and your findings. So you're going to be asking and getting more information than is actually ultimately relevant to your findings. So just remember, the interview is broader than the report. The report will not be and should not be a play-by-play of all the information that you gathered. But the information that you gather should have some sort of logical connection to competency examinations broadly, to understanding impairments or to understanding competency related impairments. So again, the report focuses on the information that you later determine was relevant to competency. Now, typically, when we start asking these questions, we'll say, like I said, I'm going to ask you a lot of questions here, and I'm going to start with asking you some questions about you. And I'm going to start at the beginning and asking them where they were born and raised. Why do we start with history rather than getting straight into the case or straight into their work with their attorney? Well, the general recommendations here about starting with history. One, these questions tend to be easier for people to answer. Factual background information about, where they grew up, who raised them, how was school, all of that. You're also getting the person to talk a little bit about themselves. It's less anxiety provoking typically than talking about charges where their civil liberties are at stake. Early background questions can also serve as an icebreaker. that gets the person feeling like this examination is less of a foreign experience, particularly if they've never done one before. And you come in and you say, I'm a psychologist and I'm examining your competency for court. That can be a little nerve-provoking, especially for somebody that's not familiar with what that is all about. And getting relevant information that they're capable of providing, or more basic information about themselves, may ease some of that initial anxiety and have them see like, okay, this isn't as foreign of an entity, all of this as I thought. I'm just answering questions about myself right now. I can listen and tell this person that stuff. But the information in the background is also going to be potentially relevant to understanding the person's history of impairments and any current impairments right now. And this is also a mechanism for you to be able to start observing any cognitive, emotional, intellectual, behavioral functioning, how the person is reacting to these basic questions, how they describe their background, how they react to your questions, the level of detail they provide, the level of insight they provide into their background can give you a scope or a hint of where you might expect some potential relevant issues down the road in your examination. It can also assist in your assessment of response style. If you have information that is wildly inconsistent with what they're reporting of their background, or if they're reporting deficits or a lack of deficits that doesn't match up with what you know generally about that evident impairment or what you know about them, that could raise some eyebrows. Um, I remember one of the first anecdotes early on in my doc training with one of my colleagues who was doing one of his first competency examinations was somebody that he had later on with his supervising psychologist determined had feigned impairment, and um, he asked him about who raised him, and the defendants said, "Oh, I don't know." Um, and then when he asked him for what his mother's name was, the guy looked shocked and then looked almost euphoric and said, "I have a mother?" Um, and that was his first sign of later on some more incredulous confusion and surprise that the person was ended up relaying throughout the rest of their examination. Sometimes, somebody may not know what their mother's name is, but somebody who becomes surprised and overjoyed at the concept that it turns out that they have a mother, that their mother existed at some point, is highly unlikely. So this is typically why we start with this. It can serve a number of different factors in understanding, but also easing the person into the examination process. Now, in terms of your note taking or your follow-ups, the question is, you might have a template of the kind of information that you're going to be gathering during your examination. Um, some of the information is ultimately going to prove irrelevant to you. On the surface, it might prove irrelevant. Um, there's other information that on the surface seems clearly relevant. And then there's that middle ground where stuff that you're hearing could potentially be relevant to this person's competency. Um, so let's say, as an example, you're asking developmental background, upbringing, and you know, you're asking who raised them. Did anybody else live in the home with you growing up? Um, and they say We briefly had a dog for like 3 or 4 years. They were in the home with us too, um, as a kid. Not unlikely to be relevant to understanding their developmental background, to understanding any kind of impairments or understanding their competency. Um, when something is on the surface as irrelevant as that the person had a dog at some period growing up, um, I'm not going to dive down that line of questioning before. So I don't need to know, oh, what was the dog's name? What kind of breed were they? How long exactly what age were you when they were in the home? Are they still around? Did they pass away? What did they die of? All that information is bringing us down a train of thought that is not going to give us any information relevant to competency. So I'm not diving into that. I'm not taking additional notes. I don't even need to write down that the person had a dog um, in that moment. Um, I'm just moving on with the next line of questions. Uh, Stuff that is clearly relevant. You want detailed notes on as much word for word for particular areas as possible if the direct words are relevant to capturing what the person is communicating to you. Now, there are two critical exceptions to note-taking um, information that is clearly relevant. One would be their accounts of the alleged offense, their accounts related to what they were doing at that time, around that time, um, and also the details around specific legal strategies that they're contemplating. This is where typically our notes will be more vague, where you can say legal strategies dot rational, logical, accounts, not illogical, not irrational, rather than actually detailing in your writings what they specifically said that could have admitted guilt or could be revealing to what they would consider doing in court. The possibly relevant stuff. This is where your clinical skills of tell me more and going down different lines of thought can help clarify how relevant this information might be, and note taking so that you have this information later on. And if the information ends up irrelevant, then you don't put it in the report, but you have it as you're diving in if it could be relevant with the other information that you have later on. So in terms of what this interview is going to cover, the background information aspect, it can cover a number of different inquiries. And again, you don't know until you actually get the information if there's going to be any relevant information in each of these categories, but you're nonetheless going to cover these categories to get potentially relevant information. So information about the person that has been demonstrated as potentially relevant to somebody's current competency standing, their developmental background. So understanding anything about early development in childhood, hitting milestones, stability of family, any kind of notable medical head-related events, any kinds of notable adverse life events that could have implications for psychiatric or cognitive impairments in childhood or down the road. We're going to be asking a lot about upbringing, social and family history. So who they were raised by, who they were surrounded by, who was around when they were kids, family histories of psychiatric impairment. That's an example of something that could be potentially relevant. If you, particularly, for example, if if you're examining a defendant who is 19 years old and there's very limited information on their psychiatric background, and they have a very limited history, but they're at that age where onsets of certain issues could be emerging. And you've got only these vague symptoms, but you have a family history of certain psychiatric disorders that align with this and are known to have a biological or genetically shared component to them, that could be relevant information to you when you're trying to understand the likelihood that things that you are seeing are related to a certain impairment. So you're going to ask about social upbringing. You're going to ask about current support system, where they were living before they got locked up, who they know, who they talk to, current social functioning and social relationships. Can also be important to ask about if through your examination you determine that talking to somebody that knows this person outside the context of your interview, particularly if they know this person outside in their community living where they're detained right now, if talking to them would provide a good perspective. So hearing that their closest person is their mom. Maybe I want to talk to mom, depending on the information that I understand about this person during the examination. Um, Especially if they say, yeah, I was first treated at 18. I don't know. My mom would be able to tell you more about why I was in the hospital then. I don't remember. Well, if someone explicitly says that, it could very well be helpful to talk to mom. That also gives you an inclination of maybe there are hospital records, and if this person doesn't know the hospital, maybe mom does, and maybe I'm able to access some records through that. So that this can be very helpful in terms of knowing other people that you might want to talk to. You're going to want to dive into educational history, how how far along the person got in school, what their grades were like. Were they ever, did they ever get help in school? Any kind of special education classes? Any kind of learning disability? What kind of things did they have? What kind of subjects did they have a hard time with? Do they remember getting any kind of help from teachers or other people with that kind of subject? Did they have to repeat any grades? If they didn't complete high school, how far did they get and why did they leave? Uh, do they have other kinds of degrees or certifications? All of that can give you some snapshots of their potential knowledge base, their developmental understanding or capacity during the developmental period, their interpersonals. Did they have friends? Were they ever suspended or expelled from school? How'd they get along with teachers? Um, Stuff that could be potentially relevant. And then the vocational background too. What kind of jobs have they had? Have they ever sustained themselves? How have they made money? Um, you might ask what kind of tasks they've been responsible with for jobs. Getting an idea of the level of skill, the uh, the issues the issues that they've demonstrated in terms of sustaining employment or not sustaining employment. Have they been fired from jobs? Have they had extended periods where they've been unemployed? And what are the reasons for that? There can be wild differences during a competency examination for somebody who has had very limited employment history and been fired multiple times because they get in arguments with their supervisors because they like to do things a certain way and they get in yelling matches and then just skip out and say, I'm out of here. Versus somebody that's gotten fired the same amount of times during their probationary period or early on because they're not functioning the basic tasks and not grasping the job. And then diving into what were the responsibilities of that job. What kind of tasks were they having difficulty grasping? And, you know, I've had people that have described, oh, I'm in construction, but I want to know more about what they were actually tasked with doing in construction. Because there can be people that are at different levels of planning and blueprinting and troubleshooting on the job. But I've had other people that say they're in construction, but were really just told at some point to like go wheelbarrow this over there, or that person needs more bricks, go give them the bricks. Much more concrete direct order tasks that require less cognitive capacities and demand in the moment. Getting a snapshot of not just what the job roles are, what field, but what they actually had to do, how they actually completed that can give you hints and snippets into functioning. Medical history. This is an example where, in particular, a lot of stuff that you ask that could be potentially relevant, but ultimately proves irrelevant. So somebody can say I'm on medication for high blood pressure. That's ultimately not unlikely to be relevant to competency. Um, I had having a surgery on my left knee from 15 years ago. That's probably not relevant to competency. But a brain surgery from 15 years ago could be quite relevant, understanding what the surgery was related to. What did the surgery entail? Did they have an examination afterwards? Um, so diving into any known surgeries, any medications that they're on now, any medical conditions that they have right now, history of traumatic brain injury, history of loss of consciousness. These are all things that can both tell you medical histories that can be relevant to current impairment, as well as knowing any kind of current medical conditions that you want to rule out are causing any concerns that you have right now. So, as one example here, you let's say you had concerns in the moment about somebody's concentration during your examination. They don't seem to grasp anything that you say. They look almost zombie-like to you. They're not showing a lot of emotion. Um, Maybe these are negative symptoms of psychosis. Maybe they are on a heavily sedating medication for a medical issue that is affecting their presentation right now. It is important for you to be able to rule out acute capacity and how much medical issues or non-psychiatric medications could be factoring into the person's current impairment. So we ask about current medications, current medical conditions, so that we can dive into how much that might be impacting the person that we're seeing in the moment. Mental health and substance use history, of course, will be relevant to assessing any mental health conditions or relevant impairments that could affect competency, especially those that affect reality-based understanding and mood and emotional lability, those kinds of things that we'll dive into. History of psychiatric hospitalizations, so that we can get into a documented history of how intensive services have been, which can be a proxy for the intensity of the symptoms before, and also potentially diving into records that could tell us later on how have mental health clinicians observed this person at times outside of your competency hearing, when symptoms have been particularly high. It can be very helpful for us understanding the scope of deficits that have been seen in a mental health condition to see how likely that is and resembling the person that we see right now. Substance use history. We have many substances, of course, that can have psychoactive effects in the immediate and also long-term effects on the brain and on behavior. We want to know illicit substance use, the extent of substance use, any history of getting in trouble with the law for substances. All of this information could prove potentially relevant to understanding somebody's competency, their exposure to court in the past, their familiarity with court proceedings. especially if their current charges are substance related. Legal history. Have they ever done a competency exam before? Have they faced charges before where competency has come up? I would hope to get records of any past competency exams so I can see how they've presented there, what the impressions have been. This also can give you a background of how familiar the person might be with court proceedings in the legal system. Looking at not just how many arrests they've had, what they've been for, especially if they're similar to the charges that they're facing now, if there's anything from court records that indicates they've gone through a trial process before, versus somebody who this is their first court appearance, the first time that they've been in trouble with the law. And thinking about generally, if somebody expresses some initial confusion about some basic court proceedings, how much of that is based on pure ignorance and sheltered life? I've never been to court before. Haven't been exposed to much stuff. I only have what I've seen on television. Um, and it's less of a capacity to understand and more about a naivete because I have not learned this stuff before. Versus somebody that expresses similar levels of confusion about basic court processes, but you have evidence to indicate this is not their first rodeo and not even their 10th rodeo, that they've been to court, they've had attorneys over 20 times, and they still don't know what an attorney can do for them or what the plea options are, even if you have indication that they've pleaded guilty or they've pleaded not guilty before, but they don't know what those mean. That's going to give me more pause for someone that has an extensive history of doing that and exposure to the legal system versus somebody who this might be their first time ever dealing with court. Okay, so let's take a brief, just 3 minute blink stretch break right now. I'm having trouble with where this is looking at the time. Um, but I have 9:47. So I'll start again at 9:50. All right. I hope everyone had a nice little reset there. We'll go ahead and continue on here, getting from the background to the person's, getting more into the legal and court proceedings aspect. So you've created a foundational piece of talking about background, about talking to the person, and now we're easing in and getting into court proceedings. Now, this is where we're going to start with an assessment of their understanding, their ability to participate in the legal process, and you're trying to also understand their behavioral, cognitive, emotional functioning, focusing on any kind of impairments that might impact their understanding and ability to participate in the legal process. The background information might provide you a sneak peek of what to expect, but it's really diving into this stuff that often gives us the meat and the compelling evidence of a person's competency or insufficient competency. During this discussion, you're also wanting to identify connections between any impairments that you may see and any limitations in competence that you then observe. Generally speaking, in other states, if your order includes comments on restorability or specific treatment recommendations for restoring competency, you would be also asking questions that get into the prospects, the likelihood of boosting, achieving competency, identifying ways that would be remedied. This is not applicable to New Mexico orders. We are not asked to comment on restorability or identify treatment recommendations, so you don't need to dive into what treatment has worked, what treatment has not. Any kind of considerations in terms of knowledge base or improving knowledge or addressing psychiatric impairments to restore competency. But you will address hospitalization commitment matters if appropriate, something we'll get into after we talk about the competency examination part itself. Remember when you get into the court-related issues, the difference between adjudicative competence and decisional competence. The adjudicative competence components, again, are more about those internal processes of does the person have a core understanding of proceedings? Can they understand stuff about their case? And decisional competence includes using that information to then make rational decisions and take rational actions. The adjudicative part is what we would typically start with because it is the foundational piece here of competence. You can't make rational decisions without having a reasonable understanding as a basis to make those decisions. It doesn't matter what the decision actually is, as much as the basis for it. So the difference between something on the surface that could be sensible, but if it's not based in an understanding or proper understanding, it's just, well, that's what my mom told me to do, so that's what I'm going to do. Maybe mom gave him good advice. Maybe on the surface, like, okay, it makes sense to want to do that in this case. But if the person doesn't actually understand what they're doing, they're saying, Mom told me to do this, and what does that mean? I don't know. You want to understand not just what their decisions are, but diving into the fundamental basis for it. And so the first things you're assessing are core understandings of things related to court, their case, and then looking at what they want to do with that information, how they can make decisions in their case, how they can consult with counsel. And these next couple of slides, we'll get into some more specifics in that realm. So I'm focusing here on the New Mexico prongs. There's technically three. I consider one of them 3A and 3B because they seem like separate conceptual issues to me. But prong one, thinking about rational and factual understanding of the proceedings. So this is when we're looking at factual knowledge about basic court in general. What are the plea options? What does a district attorney do? Or a prosecutor? What does a defense attorney do? What does the judge do? What does a jury do? Um, when you say the plea options are guilty, not guilty, what if somebody pleads guilty, what are they saying? What does that mean? And what happens to someone if they plead guilty? Or what happens next if they're found guilty? Versus what happens if somebody pleads not guilty? So you're asking questions not just can they provide a definition, but do they express a basic understanding of I can appreciate the difference between being found not guilty. I get to go home, charges are dropped, versus if I'm found guilty, oh, then I get sentenced, I get punished. Do they have an understanding of the case details in their case specifically? So, one thing about foundational, do I understand court proceedings in general? Do I understand the basics about my case? What I'm charged with, regardless of what happened, what are the police saying I did, or what's the state saying that I did? How much time I could be looking at? Is this a felony? Is it a misdemeanor? What are they saying that could be evidence against me? What is their abstract legal knowledge? So do they understand, like, if they plead not guilty, what happens next? What is a trial? So what happens at a trial? They might say, I don't know. We'll get into what happens when somebody initially expresses confusion, of course. What is a plea deal? But also, what are the pros and cons of a plea deal? Why might someone say taking a plea is a bad idea? Or why might someone say taking a plea is a good idea? Okay, if you don't take a plea deal, what happens next? They could offer another one, or we continue on. We go to trial. All right. So what are the good things about going to trial and not taking a deal and going through the whole trial process? What are the bad things about that, or why would someone not want to do that? And getting an idea of not just their ability to repeat definitions, but showing their appreciation for it. Now, one thing I want to emphasize here in terms of this factual understanding of their case and their legal knowledge. This is not a test. This is not something where you're grading right or wrong and a percentage leads to failing or passing. So there is no how many do they need to get right or how many can they get wrong. Now, there might be some questions that if they get wrong, how they get it wrong or why they get it wrong might be influential into your impressions of competency. Not all questions are equal, but it's not as simple as a person needs to know this many things about court or needs to know these things about court to be competent. And if they know one less than that, they're not competent. You're also going to be considering if somebody's answers are factually wrong. Is it wrong because they don't understand or because it's not realistic? Or is this a matter of precision? So it might not be as clear cut as this is wrong and therefore doesn't show an understanding or stuff that we might not consider wrong at all. So as an example here, I think many of us can still get a little confused about legal definitions between battery and assault. And a defendant says, I'm charged with assault, and they're technically charged with battery. Now you want to give them the information of what the technical charge is. But if they're telling you, "Oh, I'm charged with assaulting that person," they're saying that I punched them and threw them to the ground. And that's exactly what the criminal complaint is. They keep using the word assault. The idea there, do they actually understand the charges and allegations? You can highlight that they didn't retain the name of the official charge, but that's going to carry less weight in terms of my assessment of how well they understand the proceedings and what they're charged with. If they're using the word assault, but they're understanding at the core, they're charged with what the state calls battery, and they also know the maximum sentence that's associated with that. Basically, one of my decision-making trees is like, if they corrected themselves and actually got it right, that it was battery versus the name was battery versus assault, does that change anything about their understanding of the proceedings or how they would move going forward? That's going to carry less weight to me versus somebody that gets it factually right, but their understanding of the allegations are not within the realm of possibility. So they say I'm charged with battery, and they say that, oh, it must be battery, they think I stole some batteries. That is a wide error that doesn't get at the core of what they're accused of. And again, that decision-making tree for me of like, if we corrected that and they grasped, I'm not charged with stealing batteries, I'm charged with assaulting someone or hitting someone, that would change how they're going to react to the allegations. It's a completely different set of allegations. It's an understanding of who could be a witness or what they're accused of doing. Now, as is noted in the chat here, yes, um, I want to initially clarify that I stopped sharing by mistake. I'll do that again. Um, I certainly want to clarify with the person that they're actually what the official charge is. What I'm talking about here, at least in terms of assessing their competency, is when you get to that ultimate conclusion of assessing their factual and understanding. You want to give them the information that gives them the opportunity to be as precise as possible. But we do have leeway here in terms of how precise someone needs to be to demonstrate reasonable understanding of the proceedings. The difference and we will all, as Randy got into last week, in terms of the definitions or how precise we are with some terms in terms of what is a prompt arrival. There's also some judgment. We might have different definitions of what is prompt. There's a little bit of subjectivity that gets into how right or how wrong somebody's information they relay to you is. Now, if it is wrong or imprecise, we do want to educate the person so they have the opportunity to be even more precise. But there is a difference when we get to down the road assessing their fundamental understanding. If, for example, somebody is facing a number of different charges and they tell you that I think I recall my lawyer saying if I got convicted of all this, I could be facing up to 8 years. And it turns out that it's 7.5 years when you add it up all together. You certainly want to clarify that with them. Later on, you ask them again, they say, I think it's about 8 years. Um, you might have some leeway there in terms of, okay, they still say eight. The maximum is actually 7.5. There are implications there of how well they understand what they could be facing. What's helpful there for me is the person is showing an understanding of I can face several years and I can face enough years that certain decisions about plea deals or maximums could be relevant in terms of how far off it is of the maximum sentence. But it's unlikely, for example, that somebody's understanding of 7.5 versus 8 years would factor into whether they accepted a plea deal of 1 year or not. Maybe, but the odds are fairly small, for example, if that somebody's going to go, well, a 1 year deal gets me 7 years off of the max sentence, so I'm going to take that. But if it had been 6.5, I wouldn't have taken it. Now you want to understand if that indeed is their decision making, that it is critical that they understand the difference, and it does factor into their competency and understanding there. But there's a difference, I think, for all of us subjectively right now. For somebody that says 7.5, 8 years when the maximum is 7.5, versus somebody that says the maximum is 6 months, but it's actually 7.5 years. That is, and again, we might have some subjectiveness about how off somebody could be, but it's to emphasize that this is not a absolute right or wrong test, and they have to get it precise. They have to get X amount of questions precisely right to show understanding. You are looking at all of the evidence to look at fundamentally, does the person have sufficient understanding of the proceedings? Yeah. And Randy provides another example here. Somebody's a plea of not guilty. Yes, not necessarily denial of the offense, but almost all definitions will offer you're saying you didn't do it. Do we clarify that? I've seen some people asking about like what is not guilty by reason of insanity in a case too. Um, that question and the understanding and how well they understand not guilty by reason of insanity could very well be relevant for someone where you have also learned that an insanity defense is potentially being proposed by the defense attorney. If they are considering an insanity defense, they should know what it means to plead not guilty by insanity and what happens after that. But again, the level of detail that I'm going to give and that a defendant needs to understand about what happens if somebody's found not guilty by reason of insanity versus would I give a doctoral class on forensic psychology and how well they test them on the preciseness of the indefiniteness of the hospitalization and then how often periodically the assessment of release and what kinds of gradual release come up. I don't need to get into all of the halfway housing and periodic hearings and all of that during the competency examination. So you're thinking about what is reasonable to allow the person to proceed and make informed, rational decisions about their case. Yeah, Andrew, yeah, the no contest plea. Some people express a lack of familiarity with it. And again, you're talking about the level of precision. What is reasonable to say? Do they have enough of an understanding of this to go to continue on and factor that into their decisions?
Hey, Anthony, can I ask one brief question about that that's kind of come
Yeah,
up in some evaluations?
absolutely.
Not so much of the evaluations, but more in terms of feedback I've gotten from attorneys is that when we sort of go through this and we mention a no contest plea, I've had a few defense attorneys or public defenders say, well, you told them that it could result, that result could be similar to a plea deal. But that's not likely. That this district won't make that deal. Um, is that something you've run into, or is that something that like I kind of just threw up my hands? I said, look, like I'm not familiar with the nuances of this jurisdiction and how those deals are made, but he showed an ability to understand that this is an option if it were available to him.
Right. And we don't want to, yeah, there's a balance. I haven't gotten any feedback like that directly from any defense attorneys, but you always want to take that feedback to heart because although the purpose of your examination is to assess whether someone understands things, you also certainly don't want to provide information that suggests you're nudging them toward a particular legal strategy or giving them information that would provide the basis for definite for decisions that would be incorrect. We're focused more on core at the core, basically, do they understand and could they understand what a no contest plea is enough that if it came up in their case or jurisdiction, they're demonstrating the capacity to retain whatever is relevant about the no contest plea in that situation, at least at a level of detail that would be appropriate for them. Rational understanding of the proceedings as well. You have to have a factual understanding to then have a rational understanding. Are there like non-delusional versions of the events? It doesn't necessarily matter if it clashes with the allegations, but again, you're getting at why are they saying things that clash with the allegations? Does it seem rooted in psychiatric impairment or a fundamental misunderstanding of what the event even is that they're being accused of? Somebody's saying, well, I didn't do it. It wasn't me. That's not inherently irrational, even if they're like, well, there's 50 cameras and there were three witnesses there, and the witnesses are your neighbors that all say they've known you for 7 years. So, in your head, you're like, this is not simply the case of like, I saw this person and it looked like this person. It's I've known this person for years. That's the person I saw that did these things. And they say, well, I didn't do it. That's not inherently irrational, but understanding why they're saying they didn't do it or what they want to, what their accounts are, gets you into whether or not they are capable of providing a rational account, regardless of if their account lines up or demonstrates a defensible inconsistency with the allegations. Consulting with one's lawyer, knowing who their attorney is and what their role is. Again, here's where, precision comes up, where somebody says their attorney's name is Brandon and their attorney's name is Brent. That's not something where I need to say this person doesn't understand basic things about their attorney because they get their name wrong. But if they think that Brent is actually the prosecutor, and that is the person that's talking with them, but is actually the person that's trying to convict them, that is a fundamental misunderstanding that would have impacts on decisions that could compromise competency. Knowing what the attorney can do for them, how they can help them, what the limits are of, or what confidentiality is, what privileged communication is. And again, they don't need to know the difference between privileged communication versus confidential communication. They don't need to be able to explain which things are privileged and what does confidential mean and all that. But do they get the core understanding that these privileges and all that allow them to be honest and talk thoroughly with their attorney so that their attorney can help them and also provides safeguards from their attorney sharing that information with others in ways that could hurt them. They know that the stuff that they talk about with their attorney, they can talk about it in a safe place. Do they get the gist of that? Their willingness to trust, to talk with, and to accept communication from their counsel. Communication is a two-way street. Can I deliver information? Can I intake information? And to consult requires both. I need to be able to share relevant logical information with an attorney. I also need to be able to understand relevant logical information with that attorney and then use that in my sharing of information. Communication deficits and composure in court. This is where I start to think about envisioning my interactions with the defendant translating to their interactions with an attorney. This is where you're thinking about somebody's pressured speech, their disorganization, for example, with you. If they can't keep a train of thought and you can't get any questions in to have a productive conversation when you've met with this person for 3 or 4 hours, you're thinking about the implications of how that could translate to them meeting with their public defender for a period of an hour or two right before court, and their attorney trying to gather information from them and sharing information. How might the deficits that they show with you in communication reflect on their abilities to consult with counsel? The report template characteristic of this prong is the precise definition here, rationally consulting with defense counsel. This is more of the broader discussion of the prongs. Prong 3A, capacity to assist in one's own defense. So this involves a little bit less of the communication aspect and more of the rational understanding and rational application of information about their case to then make rational decisions to proceed. So one, do they have a rational understanding of not just what they're accused of, but why they're accused of that? They don't have to agree again. This doesn't mean that what is the criminal complaint is the gospel here. They can have their own version of events if there are any events at all. But do they have a rational understanding that what's regardless of what they believe is true, can they understand what, given what the allegations are, what the state might present that as they make their case that this person is guilty? So in thinking about a sexual assault case where the charges and the criminal complaint is based on an eyewitness account and on DNA evidence, can they understand that regardless of what they're saying about if they are guilty or innocent, can they understand that those, both the witness account, that's the person that says they assaulted them, and this DNA evidence would be stuff that the state might present or is likely to present in trying to demonstrate that they're guilty? Versus somebody that only keeps saying, well, that witness described me as wearing a green shirt and I don't own any green shirts. And they're not processing the DNA evidence that that the state is planning to present. They need to be able to appreciate or show appreciation that regardless of their accounts, that regardless of what they're saying, what happens, what is the other side, what would the other side be saying as demonstrating that they're guilty? So the other side is highly unlikely to be trying to prove in court that the person was wearing a green shirt and not going to be talking and emphasizing the color of the shirt. They're more likely to focus on that DNA evidence and the victim's statement and report. Can they appreciate that and have a general assessment of reasonably what to expect? If they don't know what evidence could be presented to them, that could be reasonable too, depending on the details of the allegations and where we are in the process and what evidence has been shared with them. So just because someone says, I don't know what they're going to present, one of my litmus tests is from the information that I have here. If they've had the same information and I don't have a clear idea from a criminal complaint what they're going to be presenting, then why would I expect the defendant to? If they haven't had this conversation with their attorney yet and they don't have as notably more information than I do. You also want to look at a core fundamental of their ability to make decisions because the future of their proceedings is unpredictable right now, especially if we're at the early stages of hearings. We don't know what offers are going to come up, what evidence is going to come up, how things are going to go. So we need to know not just what they would like to do, why they want to do that, and if certain things change or progress, if their lawyer has specific recommendations, what factors in for them about whether or not they're going to follow their attorney's advice. If they intend to take a plea deal, one, do they understand what the consequences are of taking a plea deal or what the implications are? And what would their reasons be for taking a plea deal, or what would their reasons be for not taking a plea deal? Now, this is stuff where I'm not detailing in my notes what pleas they would accept and what pleas they wouldn't. God forbid that gets into state records, or they have access to my notes, and then it says, person said they would take a plea if it was this charge, or person says they would take a plea if it were 2 years or younger. Now you can see how that would factor into state decision making. In fact, this gets into, a notable thing that we're always diving into rationales about why someone wants to do what they do versus what they're actually doing. And so I had, as one example here, I was evaluating a defendant who, when we got into, I tried to present hypothetical plea deals in a case similar to his, where, someone's facing the maximum time. This is where also I can informally assess their understanding. If they didn't remember the max time when I asked them before, I can assess whether they retained what I told them there. And like, so let's say somebody's facing similar charges and they're facing that maximum sentence. And do you remember what that maximum sentence was that I told you? And I can assess their understanding there. They say 6 years. Like, yeah, 6 years exactly. So they're facing 6 years. And their attorney says, look, the state's offering a deal that if you go ahead and plead guilty to this, they will recommend to the judge that you get just 1 year instead. Um, what do you think? You think that person should take that deal or not? And the goal here, whether it's directly in their shoes or in hypotheticals, is to explore what they're considering, and do they have an understanding that shows they're capable of weighing pros and cons. They know what the risks are of, if I don't take a deal, if I don't take that, if the person doesn't take that, they could go to trial and get the maximum, but they could get off and go free. And what they're basing accepting that plea or rejecting that plea goes into that, so that you can assess their rational decision making, not their not their correct decision, what is considered correct to you. But anyway, I had a person that we get into that, and he said, I don't want to get into. At first, he was saying, I don't know, I don't know, I don't know. But then he later got into, I don't want to get into any of that. I don't want to share any of that with you. And so I wanted to explore then why he didn't want to share that with me. And he said, well, you're saying it's a similar case to mine. Um, so somebody could assume that the advice I give to somebody else could be actually what I would do. And I don't know what's worse, but if they get their hands on this, because you said, like, limits of confidentiality, all that. If they get their hands on this, and I said I would reject that deal, well, maybe the state's going to try to scare me and say, all right, we're going to beef up these charges until you accept a deal. But then if I say I would take that deal, then they know, all right, like let's if I need a conviction, then I'm going to give him that deal because this guy's going to take that probably. So his decision making and telling me, like, he was showing me he was guarded, but he didn't actually tell me what he would do in that case, but he showed me in his reasoning for why he didn't want to talk about this and why he would not share his decision with me actually reflected not just a core understanding, but a surprisingly astute understanding to me of the plea process and what fact could factor into plea deals and decision making. It showed quite an understanding to me of this person's ability to weigh the pros and cons of certain plea deals, and he understood. He showed me through that. He understood the ramifications of if I told a DA I would take this deal, this could happen. If I rejected that kind of deal, they could try to upcharge or scare me into this. The whole core of here is understanding why people want to do something, as Randy's saying in here, rather than what they want to do. So when you ask someone, you can ask them generally what would go into, what would go into how you would decide whether to testify. What would go into whether you would accept a deal or reject a deal? Or get into what would you do? And when they say what you would do, why? You always want to get into the decision making rather than the ultimate outcome. And then the connected part of this prong that I consider a separate issue, capacity to comprehend reasons for punishment, your understanding, their basic understanding of why the current alleged behavior is prohibited and that the state says would warrant punishment. They don't have to agree that it merits punishment. But again, this gets into the why. If they disagree that the state should have a right to punish you on this, understanding why they're saying that. There's a difference between somebody that has more of a political, fundamental, philosophical belief of the justness of incarceration versus someone that has more of a delusional belief of why people are punished or locked up, or why they might specifically be punished or locked up. Can they appreciate the severity of the potential punishments? Again, do they know what they could be looking at and what that would be associated with? Can they connect? If I get sentenced to this, it's because I was found guilty of this, because the state says I did this. And can they recognize the different potential punishments that are available that they could face? They understand the difference between prison and probation. They say, "Oh yeah, I could get 1 year of probation." Um, Diving into what is their understanding of what probation would entail? They don't need to, this is again the level of precision. Do they need to know every possible condition of probation? No. Should they show a realistic understanding of some likely ones? Yeah. They should know ultimately, if you think about the core fundamentals of probation, you know, thinking about the idea that they would still be sentenced, but they would be out in the community, but they would have to follow certain rules for that period of time. That these are some of the common rules or the likely rules in this case, and that if the state determines they broke those rules, they could go to prison for the sentence. And if they go through probation and follow all those rules for that period, then they've done their sentence and then they're free. Can they get that core component of it to understand what the reasons for punishment and what could happen to them? All right. So now to some more procedural stuff. Again, I would say consider starting with more of the broader stuff about court in general before getting into case specifics. It's often, again, similar to this idea of general history before we get increasingly precise into court stuff, general court stuff before we get increasingly precise into the case. Talking about what a guilty plea and what a not guilty plea is often easier to discuss, less distressing, and easier to grasp than are you going to plead? What do you want to plead? What are you planning to do in this case? What can people do in their cases? It's easier to say what a defense attorney does rather than how have your conversations with your attorney been? What do you think of your attorney? Uh, so again, broader stuff before we get into increasingly specific stuff. Can they fundamentally understand what's going on in general? And then can they show they can apply all that information to their particular case? Now, you're also going to want to assess things that are going on in the moment. So whether it's here or even at the beginning, if you're getting the impression that the person's assent to the evaluation is waning, and you might actually benefit more from talking about their case, you can move on to their case. Uh, I've had defendants, for example, that started. I had a defendant once, particularly that started with when I talked about basic background information. Kept saying it's complicated, just deflecting all the questions. So where were you born? It's complicated. Who raised you? It's complicated. How far did you go to school? It's complicated. He finally said, I'm not going to answer any of these. Again, the why. Turns out, he says, this is a waste of my time. You said this evaluation is about my case and going to court, and you're asking me stuff about who my mommy was and how school was. This is dumb. I don't want to talk about this stuff. In that, he reflected to me, he understood or at least recalled what the core reason of the examination was. And I don't need to dive into, well, this is typically easier for us to ease into and gives me hints of your potential impairments and all that stuff. And that's why I start with this stuff. But in his agitation and his refusal to answer questions, he was reflecting to me, I was okay initially answering questions when you told me this was about court and my case. I find the questions you're asking me in my right now completely dumb and I don't get their relevance. I asked him, should we just go straight to your case? He said, yeah, that's what we're here for, right? So I fast forwarded. I felt like if I nonetheless said, well, it's important for me to get background information earlier, this guy was checking out, not giving me information. It would increase the odds that he, one, would terminate the examination early. Two, even if he didn't terminate it, that I'm going to lose rapport or the opportunity for rapport that then would impact how willing he's with me to discuss his case at all later on. So in that situation, I pivot. So okay, let's get right into court in your case. You can jump into the specifics if you feel like that's actually going to elicit the most helpful information and benefit the examination. So this is kind of a guideline of the default, but you're always monitoring the person's receptiveness and factors that could go into why I want to get into the core case and court hearing issues. As you are talking about the court proceedings and the case, you're first asking them questions about what they understand. And if they understand it, cool, go on to the next thing. If they don't show understanding, if they say, I don't know, if they say something that's wrong, or if they give you a partial answer that misses some important information that they should know, give this information to them. And then you will I advise you to note in your records there whenever you have provided information to the person. That then allows you to go back and know which questions you provided information for and assess whether they retain that information later, particularly the critical stuff. So you want to make sure that by the end of your examination, you're not saying they didn't understand this stuff and you hadn't sufficiently ruled out it was because they just didn't know it at the time, but now that I've told them, they understand. Because again, this is their capabilities to understand stuff. The proceedings could change. The status of their case can change. They need to show you, can I understand things? So if they don't have information and I give it to them, can they retain it? Maybe they've had a parent that's been relaying stuff about their charges to them, and their parent gave them the wrong name for the charge. And so they tell you the wrong name because they've been told the wrong name. And you correct them and they understand it. That is critical for us to show they had the name of the charge wrong, but once I shared it with them, later on when I asked them, they got it right. Shows that they can understand. If they get it right, anything from their response or information thereafter that could give you question into their appreciation, you'll want to assess whether or not factual knowledge translates to rational understanding. So, for example, somebody says, you ask the person, what's the role of the defense attorney? And they tell you, allegedly, it's to help you. That's factually right. Allegedly? I want to understand where that word came from. So I might ask a follow-up question. I might simply say allegedly, or tell me more what you mean by that. That gives them an opportunity to explain why they are emphasizing that that role is allegedly to help them. It could reflect just a general skepticism of the fairness of all of this. They're allegedly there to help me, but the state pays their salary and they're overworked. My lawyer didn't even remember my first name when we met, so I don't know how much they're actually going to help me. That might be some guarded skepticism based on not illogical understandings of the legal system or the process and their experiences with their attorney so far. Versus allegedly to help me and more reflecting delusional thoughts that they later express about all court parties being in cahoots against him so that they can lock him up and that they're trying to trick him, that there's the attorney there to help him so that he'll spill the beans. Again, you're assessing why they say what they say, and if in their factually accurate response they say something that gives you question to believe that they actually appreciate it, you would query in more. The other scenario where I see this coming up a lot is when somebody is showing me some fairly simplistic or concrete thought processes. And when they give me definitions, when I ask them a question and they repeat stuff, they repeat it essentially word for word what I said or what someone else says in a way that reads like, I am repeating correct words without demonstrating an understanding of it. I want to make sure people are not merely parroting what they've heard, but actually understanding it. What is the role of a defense attorney? Your side. Like, okay, for some, maybe something where they say your side, okay, could that reflect their understanding it is the attorney that helps them? Maybe it does. Do they just remember that people said the words your side and that they're on your side, but they don't actually understand what being on your side means? I might dive into that to see whether or not they're just repeating information without understanding it versus they're just talking simplistically, but they actually get that the attorney's there to help them and is on their side of the case. Once you get into the specific case, you want to discuss, again, what are the official charges? What are the possible penalties that are associated with those? Their understanding of what the allegations are. What might the state be saying that they did? What do they think of that? Regardless of what the state is saying happened, what do they say happened? What do they want to happen in their case? And again, getting back into why. All of this under all of this conversation helps you in many of the prongs here. Do they have a basic understanding of what they're being accused of? Do they have rational thoughts about what they're alleged to have done? Can they make rational statements or like think about rational things about how they might want to proceed in their case? Do they show the capacity to actually help in their defense? The arrest report, the criminal complaint, can often serve as a conversation tool here. If they say I'm not sure what I'm accused of, um, going through details of what the allegations are, how they react to that, what they grab on, do they seem to grasp what the evidence is from the report? Is it based on witness accounts? Is it based on their direct interaction with the police and expecting them understanding that the officer is going to say this and I'm going to say this? Is it based on video camera footage? Could that video camera footage be used as evidence? If they didn't know details about the allegations before, do they retain them? If they downplayed the significance of the charges, do they seem to have a revised seriousness? I've had defendants who we talked about the allegations, we looked at the criminal complaint together, and then started to get a little down and heavier and go, this isn't looking good. This is a lot more serious than I thought. When I get into tell me more about that, can help me understand what they're processing through that. That could show me, oh, they're taking in information and updating their assessment of what's at stake, what evidence the state has, how it might look in court versus them saying I didn't do it. You're making inferences about from their responses and talking about working with their attorney. Think about from your conversations, can they understand information that would reflect and have implications for can they understand what a lawyer is going to tell them? Again, you can't the conversation that you have with this person about their case is not identical to how their attorney is going to talk with them. But it does carry implications for what we might expect their capacity is to understand what an attorney tells them and their capacity to communicate with their attorney. So again, if they're guarded with you, understanding why. If they're guarded with you because they know you're not your lawyer and they know the evaluation's not confidential, thinking about the implications of that, that might not carry as much weight into their ability to share that information with their counsel. But do they have other delusional beliefs or cognitive deficits that could, in fact, impair their ability to share relevant info with counsel? How well can they take in information from you? How well can they share information? Can you follow their train of thought? Can you have a basic back and forth conversation? Is the person capable of testifying? What would it look like if they went up and testified based on how they present to you now? Their ability to stay on thought, their ability to take in information, their ability to respond relevantly to questions. Now, I've also had in these situations where we're talking about legal strategy and all that, I've had situations where, I've had a fellow, I'm supervising someone, and they said they did pretty good on most of the stuff, but they didn't really seem to get what a plea deal was, and their responses to all those hypotheticals were really confusing and didn't seem to make sense. But they got everything else, so I think they're competent. In some cases, maybe. But if we think about that the vast, vast, vast majority of cases end in plea deals, you're at a base rate of thinking, if we're at the beginning of this trial or the beginning of this case, plea considerations is a very highly likely scenario to come up. If 95% of cases end in plea deals and we're at the very beginning of this case, until we hear otherwise, the odds of this one having plea elements to it is very, very high. So a reasonable, rational understanding of plea decisions is very critical to competency unless we hear otherwise. This is where that right or wrong of different things is not necessarily equal. And that's why, again, I say you don't get into they got almost everything right, and since they got enough things right, they're competent. It's also what are they getting? What are they getting wrong? Why are they getting wrong? And the significance of not understanding that information. So by the end of your interview, you want to ask yourself, has this person shown that they are competent? Have they shown that they factually and rationally understand things? Have they shown they can rationally work with counsel, rationally assist in their defense, and comprehend the reasons for punishment? Again, not just did they get stuff right, but do they show they understand it and can rationally apply it? If they haven't shown it, why? So this is where we get to the next slide has a survey, slido.com, or your QR code as a heads up here. So if you want to participate in that, you can get your phone ready. Let's say the person doesn't show that they're competent. What is a reason that you could do an interview with someone? And what is a reason that someone could show that fail to show their competency? So there's your scan code. You can visit slido.com and enter that code. I forgot to open it ahead of time, but I believe that'll be okay. I think it's activated. Let me know if there are any issues as you get into that. It says no active polls. Okay, thank you. Oh, why is it? Okay. Might have to briefly start it again. I'll let you know. Um, I'm supposed to get a. I guess for now, in lieu of that, because it says it's active. I don't know why. Um, you can go ahead and enter responses in the chat box, perhaps instead here, and I'll try during the break to see if I can fix this for the other question or two that come up. But for now, you can just go ahead in the chat box or share answers orally here, unmuting. If somebody doesn't demonstrate competency in your interview with them, what is a reason that that could be? So they could be having delusions. They might not actually be trying. They're disengaged. Again, delusions. More of the cognitive, lack of understanding. Anything else you can think of why someone in your interview might not show competency? Hallucinations, so they're not actually processing the information. You can't understand what they're saying, or they're incapable because of disorganization. Okay. So we've got a number of different ones, desires to be found incompetent. So this may be their actual presentation, their actual understanding here. There are so many reasons that somebody could fail to show you sufficient understanding. And some of these have implications for being not competent. But I want you to think about the idea that just because this is again where performance doesn't directly necessarily translate to ability. Somebody could not show you competence in your evaluation because, again, this is their first time experience with court and they didn't understand the stuff. Um, and it's more about their limited exposure than their ability to understand. Somebody could not have actually met with their attorney before or have very limited familiarity. And it's less about their capabilities and more about their exposure, their disinterest, their mood during the exam. The guy that, for example, that kept saying, "This is dumb." Maybe he doesn't show me competency because he's upset about the point of this, so he doesn't want to answer any questions because he doesn't see the point in them. Other issues, they don't show competency. They don't show it because they can't understand your question because of a physical disability. They can't hear you, so they don't hear the question correctly. So they can't provide you information because they don't understand the question because of a physical issue, not a cognitive or psychiatric issue. They could be feigning. There could be personality issues that factor into why they seem to be on the surface incapable of working with an attorney, but that it's more of a personality issue. They express some unconventional values that on the surface fail to demonstrate willingness to consider a plea deal or willingness to work with an attorney, but doesn't actually reflect ability. Guardedness, actively high during your examination, or psychiatric or cognitive impairment. You can think about some of these. If it's because of a psychiatric impairment, then maybe that tells us that this person's not competent. But if they fail to show an understanding because they're not interested in the exam and not trying, that does not necessarily suggest they're not competent. So this is why we get into, by the end of my interview, I am thinking, have they shown competency? But if they haven't shown it, it doesn't mean they're not competent. If they don't show it, You need to take a step and go into why. Have you ruled out all the other things here that would suggest competency is still a possibility? And only when we rule all those things out do we feel increasingly strong in an opinion of not competency. All right. After your interview, there's a number of different possibilities, other things that make up the examination, of course. I'll breeze through this part. Review any records you haven't looked at yet. Interviewing additional people. Like I said before, if an obvious family member came up, and then you want to talk to them, do that. If the person's detained, I like to be able to contact detention center psychiatric staff to get more of an idea of any medications they're on, diagnoses, observations of that person outside of the context of my interview, any kind of records that have been elicited from this interview that might be relevant. The person reports hospitalizations in the recent past that you want to seek that could give you a snapshot of their disorganization before. Any testing that you want to do that can provide more of a standardized comparison or assess levels of impairment. Do you need more information directly from the person? Are you going to meet with them again? And of course, the other possibility is maybe you have enough information at this point, and my next procedure is to write this up. Um, these are a number of different activities after the interview that could get you closer to completing the examination. Some overarching principles here. Competency is focused on presentability. What abilities they show you now or show you they are capable of now way more than what they've shown in the past and what you assess they could show in the future. That doesn't mean we disregard past functioning or disregard future functioning. Those can be valuable data points, depending on what the question is or what our focus is. But how someone is doing now, competency is a present capacity issue. And so we're focused more on information that gives us a scope of their present functioning over a scope of how they've been in the past. The abilities they show and the abilities that you can infer outweigh descriptively how they actually performed. Again, this isn't a test where if you do this, you are competent. It is, does what they did reflect their ability? And competency is more about what people are capable of than what they actually did during an interview with you. Accurate understanding of information is more important than accurately repeating it. I'm going to give more weight to somebody whose repeated information, whose words differed from mine and is a little bit less precise, but they understand at its core what their charges are about, than the person that repeated my charge, but shows fundamental misunderstandings of what that means. Again, when we get back to charged with battery, it's an exaggerated example, but an important one for this example. The understanding, the difference between someone saying I'm charged with assault when they're charged with battery, but they know at its core they're charged with hitting person X, hitting their neighbor and throwing them against a wall, versus somebody that can tell you I'm charged with battery, but they think that is that they've been accused of stealing batteries. Yeah, and Natalie's example, that's one where when we give examples of what a judge does, I've had a lot of people grasp onto that referee word. Do they understand what when we're saying a referee, we mean more about like they help people follow the rules. They watch out and tell people when it's their turn to go. They make sure everybody's following the rules versus them just saying, oh, it's like a referee, but they don't get anything else from that. Accurate understanding over accurate recall. Like Randy said in the chat here, I can't stress enough the rationale for the decisions that people want to make or have made is more critical and more informative about their competency than what those decisions are themselves. People can, on the surface, make ultimate outcome decisions for irrational reasons. And people are entitled, if they rationally understand, people have a right to make unwise decisions or decisions that most people wouldn't make as long as they are capable and show they rationally understand. You can look at all the evidence there that is like, look, dude, this looks really bad. And it is like, I don't see any scenario here where if you just say, I didn't do it, they're going to follow your side. And this could lead to a conviction of 12 years. But if they say, I'm pleading not guilty, I am going to fight this because if you don't fight, you have no chance of getting off. As long as they can show you they appreciate, they've got a lot of evidence. This could not work in my favor. I could get the maximum. And I've weighed all that and I've decided, there's a chance I could get off, even if it's 1%. I am going to take that. As long as they understand and can weigh those, they can make the unconventional choice. Impairments and deficits precedent over the diagnosis. A diagnosis does not inherently inform on competency. Whether it's a cognitive impairment or a psychiatric impairment, the focus is more on what are the actual symptoms or impairments that the person is showing versus the label that it is attributed to. In fact, we have case law when we talk about cognitive deficits. State versus Linares explicitly talks about cognitive deficits. The official language in the court hearing is mental retardation, but it says that in and of itself is insufficient to say someone is incompetent. A diagnosis is not as critical to competency as the actual deficits. Deficits take priority here. All right. So I want to give you a hypothetical here. Manny says he was diagnosed with schizophrenia 6 years ago, but is taking his medication. He comes off highly intelligent, calm, and focused. He recites his official charges, describes the allegations, discusses his legal options that sound not just rational, but surprisingly nuanced. Here's one of the scenarios I was referencing earlier today. The attorney reform says Manny was disorganized, hallucinating, calling himself a federal agent when she met him. And you bring this up to him, and he says, I'm not a federal agent. I'm a federal marshal. He then tells you that everything that he just told you about his case is what he knows are the right answers. This is what I've been charged with. This is what I could face. This is the evidence I have. If convicted, I could face this much and all that. But that actually his charges are going to be dropped once he gets his U.S. Marshal's badge back, which grants him immunity because he can't actually be, he's immune, so he can't actually be convicted of all of this. So, is this person demonstrating competency in the examination? And if they are not, what particular concerns do you have? Person seems pretty sharp. They can tell you a lot of right things. So some concerns about rational understanding. So this is an example, and this is my I pulled on the thread of the sweater, and then everything seemed to unravel. This person was very sharp and told me everything that was factually right about his case, his proceedings. He even told you like these are the correct answers to show you understand how to work with an attorney, and these are the logical things one would do in a decision about how to defend themselves in this case. But it turned out that was dot 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 if that defendant did not have immunity like I do. And so I dived into his understanding of immunity and his responses and all that further on. And again, he shared with me this is what anybody else should do in these situations. He showed the capability of giving rational recommendations to people that, defendant Joe in this similar situation he could weigh the evidence and all that. But he had a fundamental misunderstanding and an irrational belief. As I dove into it more, it did demonstrate an irrational, fixed, delusional thought about his status as a U.S. Marshal. Because I asked about when he became a marshal, what happened with his badge, all these different stuff. And he said he got recruited at a career fair, I think in eighth grade or something. And that was the points of okay, we're getting into very highly unlikely. And then later on said, when I told you that I was in substance rehab for a year for methamphetamine use. Oh, that was technically correct, but I was actually on assignment to understand and get admissions of other substance use for the federal marshals. So again, like he had told me all these details that were factually correct with his documented history. Like he actually had a year inpatient substance use treatment, but his rational understanding of it was significantly compromised. So this is where somebody on the surface can show a factual understanding, but then by the end has failed to show me a rational appreciation of what he's accused of, or what the proceedings are, what the allegations are against him, what the evidence is against him, how that would factor into his actual decisions, and his ability to consult and consider his options with his attorney. As we discussed more and more what he would do with his attorney. He's like, I'll play along with whatever she says because, again, it makes sense to them. I get why she doesn't believe me. But once my badge comes back in, this all just goes away because I show my badge. They dismiss the case because I'm immune. And it also affects his comprehension of the reasons for punishment in this case. If he gets incarcerated, his understanding from the information I have would be I am being locked up because my badge hasn't come in, because they do not understand that they have wrongfully applied the law to a U.S. Marshal. All right, another hypothetical, and then we'll take another short break. The detention center psychiatrist says Garrett has a psychotic disorder diagnosis on record, and has responded well to antipsychotic medication. During your exam, he seems withdrawn. He offers vague responses with minimal substance about court and his case. He responds, I'm not sure to all questions about what he wants his attorney to do for him. I'm not sure about all hypothetical plea deals. What he hopes to happen in his case, I'm not sure. You directly ask him about these I'm not sure's. He's not giving you much, and he just kind of says, I get too nervous. I get too nervous. I don't want to do this. This person has failed to show you that they can rationally weigh the pros and cons in their case, that they can rationally that they can work with counsel to a rational degree of understanding. We have several concerns here. They have failed to show you competence. Why might they be failing to show you competence here? What do you make of his minimal responses there, as well as his response, I don't want to do this, I get too nervous? What does this tell us? What could this tell us about this person and its implications for competency? Okay, so as Andrew puts out in here, it could be volitional. He doesn't want to do it. Wanting to do something does not necessarily mean they are incapable of doing it. Has he demonstrated he's capable of doing it? What could we consider here that would help us in terms of if he's actually capable? So he could be just generally guarded, which is not necessarily irrational. So this could be something where, again, somebody fails to demonstrate competency, but they are actually capable. They are withholding information not for a necessarily maladaptive reason, um, but rather because they're concerned about what this is going to show or what they could, how this could be presented in court. Is he giving adequate effort? Maybe we give some response style testing. Can anyone think of, can anyone come up with an example here where we dive more into this and it turns out you nonetheless feel the person is not competent? So they've said, I'm not sure to a lot of stuff to you. You're probing them. They say, I get too nervous. I don't want to do this. And you nonetheless, after all of your information, you later conclude they are not competent. Can anyone think of why that might be? So this could be negative, actually negative symptoms of the psychotic disorder coming into play that are stopping thoughts, preventing them from speaking the way that they want to. The reason that they're nervous about the examination could actually be rooted in a delusion, whether they have about you or they have about the court proceedings and all of that. Um, this is also where what I will, in our psycho jargon, where I might call the availability bias comes into play. At no point in this hypothetical have we noted any potential cognitive concerns, and the detention center didn't mention them. But in absence of that doesn't mean that there aren't any there. And when a detention center doesn't note any cognitive concerns, that could not necessarily mean there aren't any, but that's not stuff that's typically of immediate concern at a detention center if the person's not causing any trouble. And if they have a psychiatric disorder, but they also have cognitive deficits, And they get easily confused and very uncomfortable and overwhelmed with information that they don't understand. I'm sure many of you have experienced interviewing somebody with significant cognitive deficits who got increasingly uncomfortable and withdrawn as they were asked a lot of questions that they didn't understand and didn't know. So we want to rule that out too. There's an example of somebody who is withdrawn, saying, I'm not sure, and it actually could be reflecting confusion because of cognitive deficits rather than purely psychiatric deficits. So again, somebody doesn't demonstrate competency, you have to take a step back and ask yourself why. And I used this one here because we can come up with a number of scenarios here that nonetheless the person is actually competent. And the reason they're not sure and don't want to participate is because of discomfort, unwillingness, non-irrational guardedness. We've also demonstrated some considerations where this could be rooted in paranoid thoughts, in delusional thoughts, in negative symptoms of psychosis, or in cognitive symptoms. So again, thinking about the possibilities here. Okay, let's take another brief 2-minute, 3-minute break. We'll come back at 11:19, and then we will wrap up part of this before we go to lunch. All right. We'll wrap up this portion before taking our extended break into lunch. Okay. All right. So if you know my speeches on clinical judgment and forensic context, and something I've even said in this a couple of times, I've thought at its core, I talk about our vulnerability to go down the train of thought that we're thinking and looking for things that support that without sufficiently ruling everything else, the other realistic possibilities out. And so my line of thought here again, don't don't rule things in until you've sufficiently ruled stuff out. So common differentials that can come up in these competency evaluations. The difference between paranoia and cynicism. Somebody could think that they have no chance in court. Again, you're getting at why. Is it based on a cynical, I know the cards are stacked against me because, and they have a general belief that the legal system believes police over defendants. And so I'm set up to fail from day one. You want to explore the reasons for that. Is there technically a possibility that a judge or a jury could believe them? How fixed, how unwavering, and what are the sources of these beliefs? Say, is this person merely pessimistic and cynical of what'll happen in their case, or cynical about their attorney looking in their best interest, versus is their reasoning and their beliefs rooted in paranoid thoughts that reflects psychosis, or some other kind of psychiatric impairment? If they show bizarre or unconventional beliefs, are they because of their principles? Are they for religious reasons, political reasons, philosophical reasons, a shared belief system versus an internal psychiatric belief system? Is it a delusional thought? Or is it a shared value of a religious group, a philosophical belief, a political group, ruling out unconventional stuff that nonetheless makes somebody capable or allows them to be capable of making decisions, but nonetheless they make decisions that most people would think is unusual or bizarre, but it's not based on a deficit that prevents them from making irrational beliefs. Again, even the most simplistic thing, I would never accept a plea, and I would never plead guilty because as long as there's a chance you get out, I'm going to take it. Even if in their case you're feeling nobody would say that. Well, this person is, and the question is why? Is it a general principle, or are they they're capable of making the other decision, or is there a psychiatric process that's preventing them? Yeah, I was saving sovereign citizens, but yeah, we'll get into that very briefly, of course. But that's another example here. Is it a delusion or a sovereign citizen belief? Are their beliefs actually fixed, unwavering, incapable of considering alternatives? Or are they stubborn? Or are they very confident or over exuding confidence in themselves? I've had defendants that seemed like they weren't appraising the chances that they could be convicted. And they were saying, yeah, there's no chance I'm being convicted. And they responded that way. But as we dove into it more, um, it reflected more of a coping skill and a stance that basically, if you, I've had somebody that said, if you think you can fail, you're already halfway there. And so it's like, no, of course I'm not going to get convicted, even though there was evidence against them. But it turned out as we explored his reasoning for saying or expressing this belief that there was no chance, it was actually more reflected in bravado and a philosophy that you don't admit weaknesses and you don't process them because it's going to happen if you admit it's a chance. But diving into, are they at least capable of considering alternatives? This comes up a lot, particularly with people with confusion or cognitive deficits. People that will say, I'll just do whatever my attorney says. Deferring to what your attorney says can actually be a very rational thought process. I'm sure outside of the function of criminal law, there have been many times all of us have been outside of our realm of expertise and have dealt with someone and go, all right, you're the expert. I'll just do whatever you said, even though I didn't understand that. Um, is the person capable enough of making an informed decision or disagreeing with overtly bad advice? Are they deferring because they choose to defer because this person knows more than I do, they know the law, versus are they deferring only because they are incapable of understanding and they don't even understand the consequences of what their attorney is recommending? So really assessing whether the person is deferring for understandable reasons or are they deferring purely because they cannot make informed decisions themselves or cannot informedly work with counsel. Again, this gets into performance versus ability. You're assessing their knowledge of court and their case, but you have to differentiate what is their current knowledge versus their capacity, their ability to understand this right now in the present day. Ignorance of the system, and also ability versus accommodations. So, ESL language, as an example, somebody that's Spanish speaking. Again, recitation versus comprehension. You rule out that someone's repeating factually correct information, but can they actually understand what they're telling you? Do they have a do they actually understand the words that are saying, or are they just recalling? These are very common things that will continue to come up in competency exams. And so I highlight these for you to think about during your exams if these related issues come up when someone shows delusional thoughts, fixed beliefs, deference to attorneys, um, recitation, always rule out some other differentials. I got a couple of more hypotheticals here. All right, so in this example here, Preston's attorney expresses concern about his ability to assist in his defense and consult with counsel. During your examination, Preston makes several negative statements about his lawyer with crude language. He says he doesn't trust his attorney because she's probably just a DEI hire and believes she'll break confidentiality because women can't keep their mouths shut. And yes, this is based on an actual case. Uh, he has a specific idea for his defense. He says if his attorney advised him for another strategy, she should learn her place and that he'll do what he wants. What are your thoughts in terms of this person's ability to consult with counsel and assisting in their defense? What tells you they might be capable or not capable of it? So no trust in their attorney. So this is where we get in the root of why do they not trust their attorney? So is this actually a value system as Natalie's talking about and as Surabhi's getting here is do these reflect a value system about men and women and some racist undertones there too that came into play versus an inability to consult with counsel? Natalie's hypothetical that was relevant here, would he maintain the same beliefs if his attorney were a man? This is an example where the person that examined this person asked them that, and everything changed there. This was an example where Preston was expressing some misogynistic views, and basically said women should know their place. Men know more than women. Men should listen to women, regardless of if they're an attorney or not. That as the man in the relationship, even if it's a professional one, it's his advice, his words that count, and he did not trust a woman of being capable of providing him advice. We ruled out other kinds, this being reflective of grandiose delusions or manic episodes and all of that. It really seemed to more reflect a particular value base that did not render them incapable of working with counsel, though it did hinder his relationship with his current counsel. So again, this is where we rule out abilities versus beliefs on the surface. All right. Ariana nods along and is very attentive during your exam. She says, I don't know to most questions, so you educate her. She repeats the things you told her, such as describing the judge as the one that's like a referee, but says she's not sure when you say things like scenarios when you follow up. In most plea scenarios, after you ask her what she thinks the person should take the plea or reject the plea, she says reject the plea. When you ask her her reasoning, she says she's not sure. Okay. What concerns, what is coming up here for you that you might need to rule out or rule in? So a cognitive processing issue, and is the person repeating stuff versus do they actually understand it? Particularly in your scenario, let's say under each of those plea scenarios, you say, should they take the plea or reject the plea? Is she saying reject the plea because that's the last option you gave her every time, and she's just repeating what you're saying at the end, or the only option that she recalls? Um, is she saying she's not sure but actually fundamentally says the default is people should reject plea deals because it could come up later? You just want to rule these things out, but this could be reflective of a cognitive deficit where someone on the surface can repeat stuff, but maybe they don't actually understand it. All right. One more scenario here. Marv has a history of psychosis, is taking antipsychotic medication. During your examination, he says God tells him everything is going to plan in his case and that'll be out soon. He expresses full confidence he's going to beat his case, but he isn't sure how yet. He says God hasn't told him what specifically, but I'll be ready when it comes. When you press him about what to do if his attorney recommended something he felt God had not said to do, he looks conflicted and replies, well, she has the law training, so I guess she'd have a good point. What do you want to rule out here? I know this is spoiled for one person in the room in particular. No, I just processed maybe a few more people. Uh, There you go. Yes. So what is the consideration here? What do we want to rule out, or what is a rule out differential here for competency? I mean, I know there are several people in here that know the answer as it translates to a case, but yes, are these this discussion of God helping him, God talking to him about his case, are these fixed beliefs in line with perhaps command hallucinations, or is this religious conviction? Is this religious guidance? And the person shows you the flexibility of, I put a lot of weight into what God tells me. First of all, does God orally tell him? Does he experience God? Is it in line with his religion? What are his religious beliefs? This is one where we really had to dive in. Does the person show the capability of weighing the pros and cons? And are they religious but nonetheless can weigh pros and cons versus do they have actually religious delusional beliefs that affect their decision making? So that's something that you would dive into and want to rule in or rule out. Is this actually fixed illusions versus can the person still make rational decisions? Okay. So some additional considerations in competency exams. If you have a court order that has multiple cases in it, not uncommon here in New Mexico, there is going to be some significant overlap. So obviously the person's background information is the same. And general court knowledge is going to be the same. Maybe the lawyer is. You're going to have to look at the cases to assess that. But the cases themselves are different. So if you have an order for multiple cases, there can be significant overlap in what you discuss in the interview, but you should assess their understanding of each case, the allegations of each case, what they're looking at. And if there are any impairments there that are affecting their performance and your concerns about competency, you want to assess how generalizable those would be across both cases or multiple cases. And what I mean by that, for example, are there hyper-specific delusions that are relevant to one case but not the other? Are there delusions that affect both cases? Or are there delusions that, regardless of the case, this would be relevant to? So here's an example here. Timo's competency order includes two separate cases, about 3 months apart, one for car theft, one for selling meth to an undercover agent. During your exam, speaks in a disorganized, pressured way where you can rarely get a word in. When you do, he responds irrelevantly and bizarrely. At one point, he complains the arrest was ridiculous because the car was mine. He otherwise does not respond coherently about court or his case before you terminate the interview. So you actually, in this scenario, did not get to even assess his understanding of the selling methamphetamine to an undercover agent. For the sake of time, I'll fast forward here. This is an example here where even if you didn't get to ask specifically about one case, you assessed deficits that are likely to translate across any case. When we think about the fact that you could not have a relevant conversation, his disorganized speech, his bizarre, illogical statements, if they were coming across the interview, regardless of the content, you can infer that they would go across other content, including any other kind of case, likely. So this is where you might say, even if I didn't get to directly talk about this case, the deficits compromise their ability to understand what's going on because of ABC. Whereas in this consideration, this is Isaac's competency order covers two separate cases 2 weeks apart, one for damage of property, one for robbery. His responses were focused but concrete, simplistic, pretty fixed, unwavering to feedback. He expressed some bizarre beliefs about being in the military, but it only came up when you asked about military and job issues. He correctly notes he faces up to a year for damage of property, but he dismisses the robbery charge, says he can't get more than a week for that one because he never used any of the money and gave it all back. He continues to say this despite you clarifying the charge and the maximum sentence with him multiple times. This is an example where somebody is demonstrating to you cognitive deficits and then shows you some unwavering amenability to feedback that currently seem to be affecting one case more so than the other. He seems to factually understand the damage to property case, but he doesn't seem to rationally appreciate the seriousness of the charges related to robbery. He has this fixed belief that he can't get more than a week because robbery is about like stealing, but he gave it back, so he didn't actually steal it. So this is an example where you might actually have information that implies different levels of competency for one case rather than the other, even at the exact same time. And that's why it's critical if you have the order in the moment and you have deficits that could be contingent on what they're presented with, that you assess both cases or all cases. All right, some other additional considerations. What if you're evaluating competency and the allegations, they say, what happened at the time? And they go, I don't know. I don't remember anything at that time. I don't remember any of this. Can they be competent? Well, again, you're looking at it's not whether they can present the best case or whether they can understand what actually happened at the time. We have to zoom out. Do they understand what they're accused of? Can they weigh the evidence against them? Can they make rational decisions? Now, it is possible that amnesia can limit and hinder the useful information they can provide. It might factor into their decision making about how legitimate the allegations are. It's like, I see what they say on paper, but I can't remember what happened, so I don't know how to disprove things. But can they use that information logically to assist and understand what could be presented at court to weigh pros and cons with their attorney? It is somebody having amnesia for the offense doesn't necessarily render them incompetent. Can they use the information that they do have rationally and sufficiently to rationally work with an attorney? Similarly to if we had the example of somebody had an effective, they said they had an eyewitness that would exonerate them. And then in the meantime, that witness dies and they can't present that person in court. That is a significant hindrance on their ability to defend themselves. But it doesn't necessarily make them incapable of doing so. You play the cards you're dealt with. We still have to dive into whether they are capable of doing this. Later stage examinations. Typically, the modal competency examination is early in the proceedings where they haven't made any critical decisions yet in their case. But competency, again, can happen at any point in the criminal legal process. So you want to make sure that this isn't a case of competency where this is a probation violation for a case that was a plea already accepted. If that's the case, you need to clarify they're defending themselves against a probation violation. They don't have to defend themselves against the initial charge. They've already pleaded guilty to that. And you're assessing their understanding of whether they understand that the punishment is the sentence for the charge they pled guilty to, but the allegations are, and whatever the probation violation is. So I'll share, a recent example here where somebody took a plea deal for a significant charge, and now they're charged with assault with a deadly weapon. And the probation violation accusations here are for a completely different charge. Let's say it's a drug charge. But the probation violation is for getting a new charge and for having weapons. That person needs to understand, at least for what we're talking about here, for the probation violation, that the punishment relates to that sentence because they pleaded guilty to drugs. And there was that suspended sentence. They could face up to a year and a half if they were determined to have violated probation. And if they're getting punished for that, it's because they're being accused of committing a new crime and having weapons on them. So what they're defending themselves, it's not necessarily sufficient for them to say, well, I didn't do that, so if I get found not guilty of the other case, then this goes away. Can they appreciate that maybe they could be found not guilty in that other case, but they're also being accused of just possessing weapons? That's not what their other charge is. It's aggravated assault with a deadly weapon. Can they demonstrate? Are they going to plan to fight this charge of saying, I'm not guilty because I didn't have a weapon and I didn't hit anybody? If they can show appreciation for what the conditions are that they are accused of violating and how they would want to go to court with it. Sometimes the defense strategies here can be pretty limited. It could be you're not supposed to test, you're not allowed to use any substances, and they test positive for drugs, and their options are basically just go there and say, oh, it's a faulty test, or pleading for, let me have another chance, or go to substance use treatment anyway. The options might be limited. As referenced before, sovereign citizen defenses. If any of you have had this experience, I do have a de-identified sovereign citizen case example, if anybody would ever like to see one. Sovereignty defenses where these can be very confusing on the surface, and some very unconventional, bizarre beliefs about the legitimacy of the state's allegations or even their jurisdiction to have charges against them. But it's a community shared belief that if it's determined as sovereign rather than delusional, does not inherently render someone not competent. They can still rationally consider their options, but their beliefs might factor into their options. It does not prevent them from making other ones, though. Defendant refuses to talk to you. Can you do a collateral only interview? Well, I've in fact been ordered to do a collateral only interview before. Or rather, I've been ordered that I can do a collateral only interview. I nonetheless attempt, even if they say you don't have to interview this person. And this was because this person had an extensive history of refusing to comply with competency examinations. And they knew that there was an extensive record history of this person. So they were already saying they expected that I would not get to talk to this person. And we're saying that if you are allowed to bypass even the effort and just use collateral if you want. I nonetheless tried, of course. I would rather do that in the event that the person is indeed willing to talk to me, or otherwise I get some notable observations. No opinion conclusions. It is possible to finish an examination and determine you cannot form an opinion on competency. No, this should be done in very, very limited circumstances. No opinions are not for it's complex and hard. No opinion is for it is complex because there is information or observations that prevent us from knowing the nature of this person's abilities. Not that it's hard to determine it, but that I am prevented from understanding this person's abilities at the moment. Whether it's because they stopped short and you simply cannot get, there is no records, there is no collateral information, and you simply cannot assess this person's abilities, and you know that there is a distinct possibility they could be competent or not competent. Whether it is because of deliberate feigning and nonetheless evidence of current impairment, there needs to be a strong, clear, compelling reason of why the current situation prevents you from sufficiently understanding this person's abilities to opine on competency. If in this state, if you are determining a no opinion, we've gotten recent guidance from the state that says if you're going to write a no opinion report, the recommendation is to alert the court immediately once you know you're going to write a no opinion report so that they can be prepared and facilitate the process of another examination if that's what they determine. And also in your report, note what would be needed in a future exam or in your exam to be able to render an opinion. So it doesn't mean you don't want to say no opinion, therefore they should get transferred to NMBHI if inpatient isn't what you're talking about is the issue here. If it turns out the person grossly feigned impairment, noting that demonstration of sufficient effort is necessary given the complexity of these cases in order to inform on competency. Or if it is records you haven't gotten, records are needed, or continued observation, whatever the reason is that you're saying why you can't form an opinion, also what would be necessary to inform one so that the court can help decide how to proceed with that. All right, here's a hypothetical here. You try to interview Mary several times, but each time detention guards notify you she refused to leave her cell. She just yelled profanities at them, which they say is just how she is. Detention records note a diagnosis of psychotic disorder on OS since at least 15 years ago. Disorganized behavior, self-talk, poor hygiene, agitation, paranoia described as severe and persistent. Psychiatry notes from 2 visits the last month describe her as the same. You have 4 prior competency exams. Each time she was opined not competent because of disorganized behavior, irrelevant illogical speech, and agitation. So the guards have notified you each time she's refused to leave her cell. So you have never laid eyes on this defendant. Do you feel like you have enough here to inform on competency with collateral only information or not? What are your considerations here? So if we talked about it before, I don't recall if we did in the last talk. I mean, one thing to keep in mind here is that competence is preponderance of evidence. Do you have enough? Is this a 51 percenter? Or is this I can't render an opinion? And there might not inherently be a right answer here, but I would like to hear some thoughts about if you had someone that was resistant like this and this is the information you have, is it enough to inform on current competency? So yes, we want as much collateral as possible. Right now we have records, guard observations, psychiatric notes from the detention center, and 4 prior competency exams. Yeah. So I'm seeing a couple saying consistency, scope, a qualified, not competent opinion. As Andrew wrote, 51%. Sometimes we call these the 51 percenters informally. If we feel like we have a more likely than not, we might have different thresholds here, but this is an example where people can make the case or have made the case that although I did not get to evaluate this person, there is evidence of at least 15 years of symptoms that detention records and guards seem to be reporting based on recent psychiatry notes from the last month. In prior competency exams, one thing I would want to know here is when these competency exams were. So, the difference between a competency exam that occurred in 2012 versus one that happened in March 2026 in terms of how they were described. Thinking about all the documents you have, you might have a more likely than not. We have a record of persistence that is more likely than not demonstrating right now, and in ways that would inhibit their ability to rationally consult with defense, to rationally assist in their defense, to factually and rationally appreciate the proceedings. So this is one where I've seen people say a more likely than not competent, which offers that qualification. And being as transparent as possible about not seeing the person hindering your assessment of their precise level of competency abilities. Okay. All right. So we will break for lunch now. We will take a 45-minute break. So we will come back at 12:45. We'll just come back at 12:45 your time. I'll go ahead and pause the recording, and then we will do a accelerated course on mandated treatment and testing before we do testimony and writing, and then that'll be a wrap. Okay, now that we are back from break, this will be an accelerated uh, version of the May talk condensed into, I guess we'll do some mandated treatment for roughly an hour, and then probably testing considerations for 30 to 45 minutes before we move on to report writing and testimony. So, assessment of mandated treatment in competency examinations is based on recent state legislation in New Mexico that requires competency examiners to opine on mandated treatment in particular circumstances. I'm going to skip the case law part here. And what we are talking about here is assertive outpatient treatment, which is mandated community-based treatment, or civil commitment, mandated inpatient treatment. And civil commitment in the New Mexico Mental Health and Disabilities Code, in general, says that people can be ordered to long-term commitment if, as a result of a mental disorder, there's a likelihood of serious harm to self or others, that the needs and likely to benefit their needs and the way they would have likely to benefit from involuntary commitment and treatment, and that commitment is consistent with the least drastic means principle to basically fulfill the state's duties to look after the general well-being of individuals while also monitoring and policing behaviors in order to keep a safe community without unnecessary infringement on people's basic lives, individual liberties. So the least drastic means principle essentially for us is does community-based treatment or inpatient treatment serve to fulfill those duties to take care of the individual and to look out for the well-being of others without unnecessarily infringing on the individual's rights who would be subjected to that treatment? The answer, of course, could be neither. But when we get into where this is relevant for competency examinations, we are talking about the House Bill 8 amendment in 2025 to our competency examinations. This is through New Mexico Code 6021B. It states that if somebody, a qualified professional, doing their competency examination has the opinion that the defendant is not competent to stand trial, they shall also include in the report their opinion into whether the person satisfies involuntary commitment in accordance to the Mental Health and Developmental Disabilities Code. That's your civil commitment criteria that I just read. So you're opining whether they meet criteria for civil commitment and whether they satisfy criteria for involuntary treatment under assisted outpatient treatment. So outpatient mandated treatment. The requirements for that, for AOT eligibility. One, is the defendant at least age 18? And have you opined this person in your competency examination to be not competent? If you have opined the person not competent, again, are they at least age 18? And then they must meet all of the following criteria. Do they have a primary diagnosis of a mental disorder? Have they demonstrated a lack of treatment compliance for that disorder? Are they unlikely to voluntarily engage in treatment that would help them live safely in the community without supervision? Here's the least drastic means principle again. Would AOT be the least restrictive way to prevent deterioration that is likely to result in serious harm to self or others? Again, this is where you're thinking of that balance of individual liberties and overtaking the well-being and policing behaviors that the state has for all of its citizens. and that they would likely benefit from AOT. So it's not enough to say like, oh, in theory they have a mental disorder and they won't comply with treatment, and this would be the least restrictive way to prevent them from resulting in harm for others. But if AOT is not relevant, if treatment isn't going to connect to the mental disorder in question, they unlikely to benefit from it, then they would not meet criteria for AOT. Um, so if somebody in the general civil realm has been mandated to AOT, what has happened is that they are mandated for initially a night for 90 days, 3 months. There is a progress check-in at 30 days. So after 1 month, there is a check-in on how they have been responsive to this mandated treatment. Are they complying with the directives? How are they doing right now? And from that initial screening of 30 days, typically an opinion is given on, given how the first 30 days are, what is the likelihood, the probability of restoration, that the person will be psychiatrically stable enough, if it's in the civil realm, psychiatrically stable enough to resume living in the community without monitoring of mental health compliance. Within our competency realms, probability of restoration. This hasn't really been monitored yet, but I assume through this we're talking about likelihood of restoring to competency, given that the charges would still be there, is basically the probability that AOT is going to benefit. And then there's a 3 month check-in. At 90 days after that initial hearing, has the person been restored in the relevant way? Do we continue AOT? Do we upgrade it to commitment? So there's a 3 month formal check-in. Civil commitment eligibility. Again, this is back to per the Mental Health Disabilities Code. HBA triggers civil commitment considerations again for all that are found not competent. We get back to likelihood of serious harm to self or others because of a mental disorder that is consistent with treatment needs, and again, the least drastic intervention necessary. So you would have determined in this case that AOT, outpatient treatment, would be insufficient to address their likelihood of harm to self or others and keep them safe. An additional question, I see some notes in the chat here. Who does the monitoring? Well, that is a really good question in that, at least for our purposes in the competency realm, in many districts, this doesn't actually happen because of that precise fact. There are only, my understanding, are 3 districts that have AOT, in practice, or at least in institutionalized, let alone in actually active practice. But within traditional AOT monitoring, there are traditionally case managers through whatever jurisdiction that after somebody's been mandated to AOT, then meets with the person and more precisely pinpoints their mental health related needs and connects them to those resources, including the whatever level of intervention, if it's door to door, if it's outpatient treatment, if it's going to a clinic for injectable antipsychotic medication, depending on what the recommendation is with the case manager and the diversion services, they would connect them with services there. The case manager is also then responsible for following up with the mental health providers that they have connected that person to then check in and see if they've been attending, how if they are complying with treatment from those mental health providers or clinicians that are at the referral source. The case managers also meet with the defendant, excuse me, because in the civil realm, there wouldn't be a defendant, so to speak. They meet with the person and also check in. First of all, did they show up with that meaning? How do they seem mental health wise? What have their thoughts on it? Have they been complying with treatment? What have they gotten out of it? And then at that 90-day hearing, it's typically, I believe, the case manager or a representative of what the institution the case manager works with that then provides updates to the judge uh, on progress. The person that's subjected to it is also present at that hearing, and the judge makes then decisions on continuing or increasing services there. So it's usually in outpatient related services, the case manager in function with the other, communicating with the mental health providers that then updates the court on what they've been hearing in terms of compliance. Is there something in the statute or code that in order for them to address the AOT question, the defendant who is recommended as comment must be in the community in which the AOT is established as well? Yes, there is explicit requirements within AOT mandates that a requirement of being part of AOT is in order to be eligible for a specific AOT program, you must reside within the district of that AOT program. So you cannot live in a neighboring district, even if there's a neighboring district that has AOT resources, but the district that you actually legally reside in does not. You are not eligible for that neighboring district's AOT services, at least how the law is written now. The second, the third, and I am not remembering at the moment the other district that has AOT services, at least in writing. I can find some resources. Is the 11th of a fourth then, Andrew? Or let's see. There was the New Mexico AOT conference this past spring provided some sources that included a map of active AOT programs in the state. Let me see if I can see where that is. Well, at the moment, for the sake of time here, this is the resource list from the New Mexico AOT conference. I believe if you go to conference slides, it was in Dr. Violet Cloud's spot. Oh, so probably that criminal competency presentation slides. I think there might be a map in there that shows. There you go. Okay, and here says 5 regions. So this was separate from districts. 5 regions with active programs, 7 without AOT, 1 in development. And you can see a map if you go to criminal competency under that resource of where active AOT programs are. And that's active as in the bill or the resources have been enacted. It doesn't mean actually that they have the infrastructure is there with clinicians and all of that. First, second, and third. All right. Yeah. Okay. Senate Bill 3 from this year is newly enacted to update the definitions of serious harm to self or others in these contexts here. So the language provided here, I will have this in your slides here. Again, like I said, it updates the language of serious harm to self or others, talking about that more likely than not in the near future, that a person will inflict bodily harm on another person. That was the old language. Now we are talking about an actual connection to past behavior. So a track that in the recent past someone has inflicted some sort of serious harm or acted in a way that created substantial risk of harm to others. and it is more likely or not that that conduct will be repeated in the near future. So this expands that definition, and we have a similar issue in similar harm to self that the person will attempt or their recent behavior has demonstrated that, or their recent behavior has demonstrated they lack decisional capacity to take care of their needs in a way that then puts them at danger of death, serious harm, or serious debilitation if treatment is not ordered. And that it makes it more likely than not that they will suffer serious physical debilitation in the near future unless adequate treatment is provided. So, what this does in terms of revising our considerations of serious harm or others. For harm of others, it adds that consideration of recent behavior, then predicting and being connected to future behavior. So it's not merely your general assessment of the likelihood that they're going to engage in future self-harm, or I mean future harm to others. But rather, you are saying this person has in the recent past demonstrated this substantial risk of harm to self or others, and that risk and things related to that risk is likely to be present in the future unless treatment is made. The changes to harm to self. Again, there's considerations of recent behavior. We also have this component of decisional capacity. So this is where we get into considerations of it doesn't have to necessarily be that the person has a history of deliberate intentional self-harm. But it could also be that the person's mental health abilities compromise their abilities to make decisions to take care of their basic needs in a way that they are likely to cause harm to themselves. So this could be this could be even argued to be extreme disorganization on the street, extreme malnourishment and disorganization that makes them not take care of their daily needs and disregarding daily needs. And that treatment would either increase their agency and decisional capacity or directly reduce their risk of harm. We'll get into the insufficient information details, but we now have a responsibility. This is where if you are determining somebody is not competent, there is additional information during your interview that you can ask and can consider for the purposes of addressing AOT and civil commitment eligibility. Doesn't mean you will get it all, but within the scope of doing your competency exam, you might need to ask additional questions that aren't actually directly informative on competency, but are directly informative on danger to self or others as it relates to AOT or civil commitment, should the person be found not competent. So some issues of clarification here. Check the court order. House Bill 8 was enacted on June 20th, 2025. There are still some out of custody areas in the state where you might get competency orders that are well over a year old. HB 8, our understanding is, in consultation with the state, applies to all cases where competency has been ordered after June 20th, 2025. So if it's about the date of the order, not the date of the alleged offense. So it could be that you're evaluating competency for somebody where the allegations and the charges come from 2022. If the order is recent in 2026, you still opine for AOT and civil commitment eligibility if you determine that they, or if you opine that they are not competent. This part is a slight update from our discussion in May. We have heard of some districts that have amended orders that do not require AOT assessment. That being said, the order saying it doesn't require AOT assessment does not overrule the law that requires you to do it. And part of the reason, at least how the orders have been written so far in the past, and every order that I've seen that's related to this, how they've been written, doesn't forbid the person from assessing AOT. It only says they don't have to do it or that it is not required. But the law requires you to do it as the code is written. It says you shall opine on this if you opine the person not competent. So there's not this necessarily, you're not violating the order for competency if the order says you don't have to opine on AOT eligibility and you do it anyway. It's been recommended that the law tells you shall opine on that if you opine the person not competent. Now, if there is some sort of language that says you are forbidden from doing that, the state would want to know that. We would need to clarify because the law explicitly requires you to do it. Um, and yeah, and Marla, and I'll get to that part in the next part, but yeah, fast forwarding basically, it is not our worry whether or not AOT can successfully or even actually be implemented. The orders only say, are they eligible for AOT? So we are talking about eligibility in concept as it has been described and mandated by law. We are not responsible for providing recommendations for what that AOT would entail. We are not providing recommendations for where the person would get AOT. We are not even providing recommendations of should they get AOT or should they get civil commitment. Our task is based on what the law says, are they eligible for it? Do they meet those criteria? Some examples here. I'm going to skip this. One thing we didn't talk about in the competency portion when we talk about notifications is that as part of the New Mexico Code, we have that discussion about when you're doing a forensic evaluation, you discuss with the defendant the non-confidential nature and also how the evaluation, how the findings will be used or how they can be used. And essentially, the updated language updates that discussion because now our reports that come from the interview that we have with that defendant aren't necessarily going to just be used for determining their competency, but it can be used to mandate treatment if the person is determined to be not competent. So I know a lot of the state examiners have updated their notifications to include that for the defendant. And I would advise you, if you haven't done that yet, I would advise you to consider how you can make that known and how you would communicate that to a defendant, because our New Mexico Code says that when providing this, even if people cannot provide informed consent, that we shall make the attempts to get them aware of the restrictions of confidentiality and how the findings from that examination could be used. And now our examinations, if the person is determined to be not competent, can be used. The judge could mandate them to treatment even if they don't want it if they are found not competent. Now, some questions here. What is a mental disorder under the law? Because the requirements of AOT and civil commitment say as a result of a mental disorder. We are talking about thoughts, feelings, and behaviors, conditions that affect our emotional processes, our thinking, and our behavior that impairs judgment, behavior, or our assessment of reality. Our psychiatric illnesses, our psychiatric diagnoses, substance use disorders do not qualify as a mental disorder that is the primary focus of AOT and civil commitment in this context of competency. Neurocognitive disorders, neurodevelopmental disorders do not qualify as a mental disorder for the purposes of AOT and civil commitment in our context here. That being said, it doesn't mean that their presence disqualifies them from eligibility. People can have, of course, co-occurring psychiatric and substance use impairments. Of course, that is actually quite common. In New York, where AOT originated about 35 years ago, there's New York data that suggests roughly half of the people that are mandated to AOT have a co-occurring substance use disorder, along with a psychotic disorder, bipolar disorder, or other kind of mental health condition that affects their emotional processes, thoughts, or cognitions. And again, somebody can also have a psychiatric disorder and a neurocognitive disorder. But the question is, the language can say primary diagnosis. What will the primary focus be? As it's written here, the statute does not explicitly require you to connect this treatment to restoration. We are not tasked in our competency evaluations to opine or otherwise comment on the potential for restoration. What we have been tasked with at the moment is first present competency. And for those who we opine do not meet that threshold for competency, whether or not at the present time they meet the eligibility for mandated treatment, whether it be outpatient or civil commitment. Both AOT and civil commitment both reference the least drastic means principle. One says least restrictive, one says least drastic. They can't both be the least drastic and least restrictive available. So if you are saying the person meets criteria for AOT and you have determined that AOT is sufficient to address their needs and decrease their likelihood of being a significant harm to themselves or others, then that is the least drastic means, and civil commitment can no longer be the least drastic means of meeting those same goals, of reducing risk of harm to self or others, because you've established AOT is. So your deference is to AOT. If they're eligible for AOT through all means, even after considering everything with civil commitment, then AOT is the least drastic means, and therefore civil commitment is not the least drastic means. And I have in here some report examples that I shared in May that you can look at that get at, well, have a consideration of what if you say they meet criteria for AOT, but for whatever reason the judge disagrees with that and you haven't noted civil commitment eligibility. A couple of language options here in terms of clarifying, like if the court determines they do not meet criteria or it's not intensive enough, then they would satisfy civil commitment by virtue of it being the least drastic means necessary under that condition. Now, getting back to AOT, Lack of compliance. Lack of compliance is related in this context specifically to whatever you said was the primary mental disorder. Lack of compliance with treatment related to that had a role in at least one negative outcome that is detailed here. So it is insufficient for you to say this person lacks compliance because they've told you in the room, I'm not taking meds and I don't want to, and I'm not going to. There has to have been demonstrated prior lack of compliance that played a key role in threatened or real self-harm, physical harm to self or others in the last 4 years of community living, or a recent prolonged detainment, lack of compliance leading to at least 6 months, a 6 month long incarceration or a 6 month long hospitalization, or lack of compliance leading to more than one hospitalization and or incarceration in the last 4 years of community living. So 2 hospitalizations, even if they're only 72-hour hospitalizations, would suffice under this circumstance if there's demonstrated that a lack of compliance contributed to that hospitalization or at least played a key role. You don't have to say the sole role. There could be other factors in there. But determining that this played a critical factor in some sort of detainment or serious harm to self or others within this 4 month of community living window. Um, I do not recall what the bases were for these specific outcomes and House Bill 8. But there was minimal mental health consultation involved. It's my recollection. Okay, so here's a hypothetical here. During your competency exam, Monty is significantly distracted by hallucinations, expresses bizarre beliefs about his charge being illegitimate. You find him not competent to stand trial. He tells you he's never been hospitalized, but in addition to his current incarceration, jail staff tell you they have records indicating he has 2 inpatient hospitalizations in the last 18 months. What are your thoughts here in terms of AOT eligibility, in terms of um, mental disorder and non-compliance playing a key role in negative outcomes? Any thoughts? More information about non-compliance, connections to hospitalizations, incarceration specifically to non-compliance. Yeah. And so that's where the key issue is, where we need to know more. We don't jump to hospitalizations mean they did not comply. Now we can pursue those records and see whether there is information that demonstrates or informs us about potential non-compliance. But many people with very significant psychiatric impairments perfectly comply with what has been advised treatment. And A certain medication is not working, a certain dosage is not, a certain dosage leads to a significant side effect that affects reality testing altogether, and that compliance was not a concern here. We need to actually connect this to these hospitalizations, or at least one of them and the detainment, to non-compliance. If they were following doctor's orders throughout all of this, but this is something that has been more resistant to treatment is not considered non-compliance. And the mental disorders resistance to treatment, excuse me. If somebody volitionally, outwardly resists treatment, that could be a demonstration of non-compliance, of course. Um, you would want to know the nature of those hospitalizations. Again, people have comorbid disorders. People have comorbid conditions. Were the hospitalizations even related to the mental disorder that you're referring to? Was it a impulsive relationship breakup, um, suicide attempt that had nothing to do with command hallucinations? Uh, so you need to be explicit in connecting that to non-compliance for the mental disorder to these negative outcomes. Andrew's side question. This is complex here. Um, my understanding is that the non-compliance needs to be connected specifically to the primary mental disorder diagnosis that you're mentioning. But I haven't seen reconciliation that explicitly notes that the primary disorder that you're referring to when you talk about AOT or civil commitment needs to be directly a key contributor to the impairments that cause incompetency. So the scenario that Andrew has laid out here, my reading on the law right now is that it is open enough that it is conceivable that somebody could be found not competent because of cognitive deficits, but it's the psychiatric issue that makes them eligible for AOT. Now, how likely that is, I can't tell you, um, but that's my reading of how things are written. And I also don't know if that's actually how it would be carried out in practice. But there's nothing in there reads to me that specifically says the mental disorder in our AOT language here and in civil commitment language must also be the primary factor in the opinion of incompetency. It only says if you've opined that they're incompetency, do they meet this criteria? All right. Can current charges be considered? The short answer is yes. You can consider current charges in terms of detainments and danger to self or others, even if the person hasn't been convicted yet. There's a couple of reasons for that. One, burdens of proof are different here. Um, I have three different burdens of proof here. Beyond a reasonable doubt, the strictest burden of proof is what is required for criminal conviction. So beyond a reasonable doubt that the person committed the act and the required mental state to be found guilty of that act. Competency is on more of the weakest standard, so to speak, the preponderance of evidence. From all the evidence that's available to you, more likely than not, including a 51% chance. This middle ground, clear and convincing evidence. So beyond mere majority, needs to be clear and sufficiently convincing, but not beyond a reasonable doubt. Clear and convincing is the standard for mandated treatment. So all of this to say, criminal conviction is a higher threshold than AOT and civil commitment considerations, which is a higher threshold than competency considerations. So it is conceivable that because someone hasn't been convicted of something yet, and yet you have enough evidence that says there is clear and convincing evidence, regardless of what happens in the case, that violence has a serious harm to self or others has occurred. In addition, the charges don't necessarily directly translate to evidence to serious harm to self or others. If you talk about aggravated assault with a deadly weapon, again, there's this mens rea component that talks about not only the act, but a specific level of intent. That specific level of intent is required for a criminal conviction of aggravated assault with a deadly weapon. It could be that the questions here are somebody's been charged with this because there is clear and convincing evidence that they caused harm to someone with a deadly weapon. But what is still of question in the criminal proceedings was their intent in that. Did they deliberately or purposefully or intentionally or knowingly harm this person with a deadly weapon? So there's the crime is a little bit multifaceted. There are also different standards of proof. All that to say, those are some reasons that you can consider current charges in the overall body of evidence to suggest whether or not somebody possesses a serious harm to self or others. You're not, if you can say that without saying they're guilty of the charge that they're facing, because the charge has a higher standard with a mens rea specific level of intent that has to be proven beyond a reasonable doubt. You are not commenting on that. Treatment recommendations. Again, this is not the examiner's role. You're assessing eligibility in principle. You're